Anybody of that, item number 57 for supplementary.
Okay. I pray to mention for listing of.
For reasons mentioned in the judgment, this revision petition is partly allowed to the extent that the impugn order directing the petitioner to pay the cost of the proceeding is set aside without interfering in the interim maintenance.
Delivery of order, item number 1.
Obliged.
For reasons mentioned in the order, this civil revision petition is dismissed.
Delivery of order, item 58 from supplementary list.
For reasons mentioned in the judgment, this appeal is dismissed.
May I approve?
Yes.
Hello,
May-
item number 62. It has come in the last of the list. So many items are there. So may I pray for updatation? Because it was listed earlier also, it did not reach. I leave it to you.
We'll see how far we can reach. If possible, we'll take it up,
Go for it.
not to. In the last,
I'll not take much time, only 10 minutes.
May I please, your lordship, I beg to mention item 61. My lord, may I pray your lordship to take it for upgradation at 2 o'clock. Because I'll be
that will not be upgradation. 61,
61 supplementary listening. Because I will be not available from tomorrow onwards till 24th of November. At 2 PM with all respect, my lord.
okay.
May I pray?
Highly obliged.
May I pray for listing of a criminal petition, your lordship, motion matter, your lordship, tomorrow, your lordship.
When have you filed?
Your lordship, it was filed on Friday, your lordship. Your lordship, tomorrow is the next date fixed, your lordship. We have challenged an order in a
Okay,
criminal.
okay, tomorrow.
Deeply obliged.
Yeah, the lordship. Lordship, I'm recommending for listing of heavy miler. And it was last listed on 3rd of November, my lord, but due to the unavailability of the court, my lord, the matter has been deferred, but still not yet listed.
You pray before registry. Pray before registry.
May I please, your lordship. My lord, I beg to mention this item for listing, my lord. Urgency is that
What item?
it's a criminal petition, my lord. The urgency is that I am for the respondent, I am for the opposite party number 2. He doesn't want to carry with the proceeding and because our engagement is in the month of January beginning, my lord. That is the reason, my lord, she wants to. Item may be either Wednesday or Thursday, my lord. We'll close it
Thursday.
first, deeply.
I have also similar prayer any day, my lord, because matters is not coming from 30th of July.
What is the matter?
Revision, my lord.
Next week on a date to be fixed by registry.
Lordship, I pray for listing for admission stays. It's a criminal petition.
When it was last listed?
It was last posted on 3/5/2024,
Next week.
next week. And
Item number 32, madam. I'm led by Mr. M.K. Chaudhary, his elder brother expired yesterday. The matter in the lower court is fixed on Friday. May I pray the-
32.
32. May I pray the matter will be taken up on Thursday, my lord. Till then, he will be busy with the religious function.
Heard Mr. P. Bhardwaj. What is your name? Heard Mr. P. Bhardwaj, who prays for an adjournment on the ground that the conducting counsel for the petitioner is in bereavement. The prayer is allowed. Let this matter be listed when?
The 13th, Thursday.
On 13th of November.
May it please your lordship. Lordship, in respect of item number 11, I'm appearing on behalf of Mr. R. Day. He has some personal difficulty today. Matter may be listed on Wednesday. Item number 11.
On request of Mr. D. K. Bhattacharya, Charji appearing on behalf of Mr. R. Day, learned counsel for the petitioner, who prays for some accommodation on the ground of personal difficulty of the conducting counsel for the petitioner. The prayer is allowed. When?
Day after tomorrow, Wednesday.
Let this matter be listed on 12th.
Oblige.
Lordship, I beg to mention item number 24 to this list, my lord. Matter may be fixed by note on next week, on next Monday, my lord, due to a personal difficulties.
Heard Mr. K. Bhuya, learned counsel for the petitioner, who prays for an adjournment on the ground of his personal difficulty. The prayer is allowed. Let this matter be listed in the next week on a date to be fixed by legislature.
Oblige.
Please, your lordship, like to mention item number 23, your lordship. Mr. Jed Alam, your lordship, he's having some family emergency today, your lordship.
Heard Ms. S. Nazneen,
Wednesday.
learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the petitioner. Prayer is allowed. Let this matter be listed on
Wednesday.
11th and 12th.
May it please your lordship. I beg to mention for listing of a urgent bill matter tomorrow,
When have you filed?
today.
It will be listed day after tomorrow.
Lordship, the matter is really urgent.
What
The
urgency?
petitioner's son's marriage is fixed on 19 November. The accused son's marriage is fixed on 19 November and he is in jail since 1st of November.
Okay. Okay, tomorrow.
May I please, lord. My lord, I beg to mention for listing of a regular bail, my lord. My lord, this matter was listed on 24/10/2025. But my lord, date was not fixed, my lord. He is, my lord, the petitioner is custody from 1/7/2020.
What is the offense?
My lord, under section 22C of.
Next
NDA
week
Act,
on a date to be fixed by registry.
Most of it.
May I please, your lord? My lord, there is a criminal revision petition fixed for the day after tomorrow. My lord, I have filed it, I am in that case file.
46.
It's only to continuation of the interim order. That was not in that particular order, my lord.
What is your prayer?
My praise, my lord, this I may be listed along with this criminal revision petition
Okay.
and deeply obliged.
May I please, your lord, so I beg to mention item number 41, my lord. Withdraw this matter, my lord, 41.
41. What is the prayer?
Going to withdraw this matter, my lord. That's
Huh?
my instruction from the client. Going to withdraw it,
You want to withdraw it?
my lord.
Heard Mr. D. Bora, learned counsel for the petitioner, who prays for allowing the
Okay.
petitioner to withdraw the instant. Instant bail application. The prayer is allowed. This bail application is dismissed on withdrawal.
Another item number 46, my lord. We are on interim, my lord, case that has not been received.
46.
After the case hearing note.
Heard Mr. D. Bora, learned counsel for the petitioner. Also heard Mr. P. Bothakur, learned additional public prosecutor, who prays for some more time for production of the case diary. The prayer is allowed. Let this matter be listed on 27th of November. This, the interim order granted earlier shall continue till next day.
Deeply obliged.
Eight please, your lordship. My lord, I beg to mention item number 65 for upgradation on behalf of Mr. S.K. Puttar.
For
Upgradation, my lord. The matter may be taken up at 2 today.
2, we have already fixed matter.
My lord, anytime today. Because this matter was listed on the 3rd, 4th, 7th and today of this month. Only amicus has to be appointed. We have served notice,
Okay, today only amicus has to be appointed.
my lord.
Okay, at 2 after the next fixed item.
Deeply obliged.
May I please, your lordship?
I need to mention for listing on regular bail application, my lord, day after tomorrow. it was
When have
filed
you filed?
On 6/11, my lord, I have filed. Day after tomorrow.
Okay.
Much.
May it please your lordship. Lordship, I beg to mention 47 lordship. In this case, we are on interim bail lordship. Case diary was called for, probably it's not received lordship. 47.
47 is there.
Heard Mr. B. Chaudhary, learned counsel for the petitioner. Also heard Mr. P. Bhattakur, learned additional public prosecutor, who prays for some more time for production of the case diary. There is
It's submitted.
charge sheet submitted.
Yes.
Then we'll,
Extend time lordship will pair and approach for regular bail. The interim may extend it.
what is the matter?
A matter lordship related to
We will take it up when the matter is called up.
lordship 47, it will not reach lordship.
Then it will be left over. You have to take chances. We'll take it up after going through the file. Wait for your turn.
Although lordship, I'm on interim bail lordship.
We may vacate the interim.
Oh, that will be- Yes, lordship. I'll-
We may vacate. Okay, next.
And is it application for listing of the regular bail application lordship? It was filed on 1/11/25. lordship. Tomorrow, lordship.
Okay, tomorrow.
In item number 15, an additional affidavit has been filed that may be allowed to attach with a record to the order.
Call for the additional affidavit.
May it be followed. I beg to mention item number 25. I'm led by Mr. B. Prasad, and Mr. B. Prasad is indisposed. That's why he is not able to.
Heard Miss, what is your name?
L. Das.
Heard Miss L. Das, learned counsel for the petitioner.
12/4/14.
Learned counsel for the petitioner who seeks an adjournment on the ground that conducting counsel Mr. B. Prasad is indisposed. Considering the ground mentioned by the petitioner, mentioned by the learned counsel, the prayer is allowed. Let this matter be listed on 14th of November.
Item
Wait, please,
41.
lordship, I beg to mention for one AB lordship. Lordship, the matter was filed, lordship, Port 11 lordship. Can I list the matter tomorrow lordship?
Okay,
Yes.
Your lordship, I would like to beg for mention for listing of a criminal application which was filed on 28/8/2023.
it is not yet listed.
It has been listed. I would like to beg for listing,
When?
any date.
Next week, on a date to be fixed by registry.
I would also like to beg for listing of an IACR criminal, which. has
Next
been-
week, on a date to be fixed by registry.
Mention for listing of a criminal revision petition for next day.
Okay.
Yes.
May I please, your lordship, I beg, I'm praying for listing of one criminal leave petition, your lord.
Next week, on a date to be fixed by registry.
May I please, your lordship? I beg to mention for item number 37 lordship.
Yes,
Can you forget to bring the file together? And matter is on admission column, lots of motion matter.
Uh,
Can we pass over?
heard Mr. What
Ad
is,
hoc.
heard Mr. R. Hawk, learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty. The prayer is allowed. Let this matter be listed in the next week on a date to be fixed by registry.
May I please, your lordship? Item number 51, lordship, I am told that CD is not available.
Yes, Mr. Bhattakur.
51 is there not received?
51. Heard Mr.
RS.
R. Islam, learned counsel for the petitioner. Also heard Mr. P. Bhattakur, learned additional public prosecutor, who prays for some more time for production of the case diary. The prayer is allowed. Let this matter be listed
On 26/11.
on 26/11.
Interim order.
The interim order shall continue till next day.
Okay, sorry. In item number 37, interim order is there.
Item number 37, interim shall continue.
Lordship.
May I please, your lordship?
Lordship, the allegation is basically, my lord will find, please to find the FIR at page 14. 1/4. My lord got it.
What is the matter?
My lord, it's regarding, the allegation is that a group of person of a organization, Bir Lassit Hena, they have
Why it was reject? Where is the rejection order?
my lord will please to find at page,
Page 23. the
Yes.
Relevant portion.
1123, my lord. Further, IO of this case in the accused forwarding report has specifically mentioned that sufficient evidence has been found against the above named accused person.
We
That
call,
much only.
we'll call for the case.
My
diary.
lord, regarding the sufficient material, if your lordship will look at page 25. So the person, he has already resigned from that organization on 2nd of September. And on 2nd of September, a new committee was also formed.
We'll call for the case diary, short date.
My lord, in another application, it's 3586, I think. The city has been called for and it has been fixed on this Friday, on
Okay.
14th.
Heard Mr. B. M. Deka,
Number 2.
learned counsel for
Okay.
the petitioner. Also heard Mr. P. Bhattakur, learned additional public prosecutor. Learned counsel for the petitioner submits that in a connected bail application, that is bail application number 3859.
My lord, 3586.
3586. Case diary has been called for and the next date is fixed on
14, my lord.
14th of November. Stop. Let the case diary be called for in this case also. List this matter on 14th along with the aforesaid bail application.
Much obliged, my lord.
May I please, your lordship? Your lordship, this is a regular bail application, charge sheet case under section 103. So the PCR may be called for along with the case. diary.
Charge sheeted case.
Yes.
Heard Mr. What is your name?
Yes, sir.
S. Soikia, learned counsel for the petitioner. Also heard Mr. P. Bhattakur. All for the scanned copy of the trial court records as well as scanned copy of the connected case diary. Registry to take steps for requisitioning the scanned copy. Let this matter be listed on 25th of November.
Much.
Well, please, your lord. Lordship, this matter may fix along with item along with BA 3599.
When
This Friday, lordship, 14th.
heard Mr. S. Muni, learned counsel for the petitioner. Also heard Mr. P. Bhattakur. Call for the case diary. List this matter along with bail application number 3599/2025 on 14th of November.
Much obliged, your lord. Much obliged.
May I come your lordship? 483 application, my lord. Apparent page number 13 to 15, my lord. And allegation is I have misappropriated the scheme benefits, my lord.
What you have misappropriated?
I have misappropriated scheme benefit, my lord.
Scheme.
I want to show the scheme first, my lord.
No, where is the rejection order? Bail rejection order.
Page 23.
Page 23.
Case diary would be required. Heard Miss M. Das, learned counsel for the petitioner. Also heard Mr. P. Bhattakur, learned additional public prosecutor. Call for the case diary. Let this matter be listed
1911.
19th of November.
Chief Developer.
That POXO sections are there, notice may go in.
Heard Mr. B. M. Dekar, learned counsel for the petitioner. Also heard Mr. P. Bhattakur, learned additional public prosecutor. It is a charge sheeted case.
No, my lord.
Let the case diary be called for. Let also notice be issued to respondent number 2 in pursuant to the prevailing notification of the registry in this regard. The petitioner shall take steps for issuance of notice upon the respondent number 2 within 3 days from the date of this order, returnable on 25th of November.
Much obliged, my lord.
Item 7. Made to the lordship. So this is anticipated bail application, my lordship. Case 13 is the FIR, my lord. Your lordship, kindly see the FIR was lodged on 8th October, my lord. October 25, my lord, and here allegation is that the petitioner was allegedly involved in corruption and malpractice in the recruitment process of educational volunteers. Now kindly see, my lord, next line, my lord, she is involved in so and so, and that complaint was made by one Zakaria Ahmed. He alleged that she manipulated the, my lord, selection process of educational volunteers. My lord, she has no power or role in that selection process, my lord, that I will show, my lord. And next line, my lord, the allegation, if found to be true, my lord. Kindly have a look at that third line, my lord. Now, my lord, kindly see this present that person, my lord, Ali Ahmed, my lord.
No, read second paragraph.
It has what to notice, my lord.
Yes.
Yes, it has what to notice that one Pallavi Sarkar, that is the present petitioner before lordship, my lord. DQM is
What is
alleged.
DQM?
That is, my lord, district quality management, my lord. These are, my lord, the contractual basis that Sarva Hikha, my lord.
Okay.
And election, my lord, that education volunteers, my lord, those are also, they work in the field, my lord, some bricklayings or underprivileged, my lord, they impart education and sort of literacy and all that, my lord. So now this person, my lord, Zakaria Ali Ahmed, he alleges that the present petitioner was involved in manipulation of the selection process, my lord. So this petitioner, my lord, she has no role, my lord. Again, my lord, next line, my lord. Under favoritism, thereby violating the norms and guidelines laid down for such recruitment. The allegation, if found to be true. So this FIR was lodged on 8 October, and that person, my lord, Zakaria, my lord, he had initially lodged the complaint. Kindly have a look at page 18, my lord. Here, my lord, should find, my lord, Annexure C, my lord. He had lodged the first complaint, my lord, against me, my lord, on 4/8/2025. Same allegation, my lord. He says he was appointed because he got that job, my lord. He was appointed, I was appointed as an education volunteer in the year 2024-25. I have been discharging my duties in MG Bricklin, so and so, so and so. When I was appointed, the opposite party, that is the present petitioner, demanded 10,000 rupees only from me. When the opposite party told that the said money will be spent in official work, I gave the money to the opposite party on bona fide belief. After getting the appointment on 3 occasions, the opposite party collected an amount of, kindly see, 4,000, 2,000, 3,000, total 7,000 by threatening, my lord. In addition, rupees 3,000 was also taken for providing sports equipment to the students, but no equipment was given. She never given the students uniform, and even she called us in the name of providing training, but after taking our signature for 2 days in so and so block, sent us back without providing any training. Thereafter, another allegation against some head teacher, my lord, that is possibly not against her specifically, my lord. Now kindly see that last page 19, that third para, my lord. That money, kindly see, it is mentioned here in that the opposite party collected the above financial transaction from me through her close associates. Those other 3 volunteers, my lord, Nazrul, Khairul, Mozammil. So 7,000 collected by, even if I assume, my lord, they had taken, my lord, 7,000 by those 3 persons, my lord. Kindly have a look, my lord. And thereafter this complaint, my lord, the complaint was forwarded to the district mission coordinator, that also find page 22, my lord. And
next page 23. Again, another allegation, same allegation to the DC, my lord, by the same person, my lord, Zakaria, on 12/8. First was on 4/8 and 23, page 23, lord should find it was on 12/8. Now thereafter, kindly see, my lord, that complaint was also forwarded and annexer E, page 27. Kindly have a look, my lord. One enquiry was done, my lord, by one, my lord, EPO, that is district officer, my lord. He had enquired, my lord. Page 27, my lord. Their lordship, kindly see the findings, my lord. The entire allegation leveled against so-and-so was found to be false, aimed at creating an unpleasant situation and tarnishing the reputation of SSA Nagaon. The written statement and relevant documents are being submitted along with this report. So this was done, my lord, and those person involved, they have been, my lord, their statement were taken during that inquiry, and page 29, my lord. That conclusion, lordship, kindly have a look, my lord.
Yes.
As conclusion, it may please to note that the entire allegation was leveled at harming the reputation of Simotive so-and-so, myself and SSA. There was some allegation possibly against that inquiry officer also, my lord.
So he will never give a,
My lord, that is true, but my lord, kindly see the allegation, my lord. I have shown what is there before the your lordship, my lord. I am not that, my lord. I am not disclosing that. There is something maybe against him, but not specific, my lord. So far the complaint is concerned. Now, what happened, my lord? After that report, my lord, that Jacare was again called, my lord. Kindly have a look at page 30.
yes.
But that was, he was called, right, my lord, that later dated 30/10/25. And what happened, my lord? And he was asked to appear on 10/10, my lord. Kindly see that I am here, that to be held on 10/10. So prior to his coming to that inquiry, my lord, this affair has been lost, my lord. Kindly see, my lord. And there are letters given to the, my lord, district officer by those Bricklin stating that I am not involved. I am not going into that. And the selection process, my lord, page 32, my lord. We have annexed one that later, my lord. How it is done, my lord. No role so far this present petition is concerned. And 7,000 allegation is that 3,000, 4,000 and 2,000 were collected. And above all, my lord, this present petitioner, my lord, she is a, my lord, that congenital heart disease, my lord, from page 40 till page, my lord, 67, my lord. We have annexed all documents, my lord. She was operated upon, my lord, in the year 2010, my lord, that open heart, my lord. She is having a hole, my lord, in her heart, my lord. Thereafter, my lord, that certificate lawsuit find page 42, my lord, medical, and page 42, my lord. That was first time when she was operated upon in GMCH, my lord, page 42. She was admitted at so-and-so Department of Cardiothoracic Surgery from so-and-so from 19 to till 13/3.
Yes, Mr. Bhatt.
Your lordship may kindly come to page 19, my lord. Another aspect, kindly
Yes.
one medical, kindly have a look at page 43, my lord.
42 is 2010 certificate.
Yes, thereafter all I have 2025 also, my lord. Kindly see page 43 once, my lord. Because for that earlier, my lord, that surgery, my lord, she was again operated upon. Kindly have a look at page 43, my lord, on 25/11/24. That lord should find, my lord. She was admitted in Narayana, my lord, Bangalore. Top right hand, my lord, admission date 25/11/24 and 4/12, my lord should see. And kindly see her final diagnosis, my lord. All those, my lord, kindly have a look once, my lord. Congenital heart disease,
Yes.
ASD closer, left, my lord, final diagnosis, my lord. And kindly see admission reason surgery. And
Okay,
kindly have a
okay.
look at that one, my lord, kindly see one, my lord, that past medical history, kindly have a look, my lord. She is positive also, my lord. So, my lord, if she is detained, my lord, that infection and everything, my lord. And even, my lord, recently she was admitted there, my lord. The last certificate, my lord, we have annexed, my lord, page 64.
Okay, yes.
Here, let me kindly come to page 19, my lord. Earlier complaint lodged by Zakaria Ali Ahmed, my lord. The present FIR lodged by ultimately, my lord, by the additional deputy commissioner, my lord, district commissioner. Your Lordship may kindly come to page 19, my lord.
Yes,
Second paragraph. It is mentioned, this is complaint lodged by my lord Zakaria Ali Ahmed earlier, my lord. It is mentionable herein that the opposite party collected the above financial transactions from me through her close associates Nazrul Islam, Khairul Islam, and my lord Mujammil Haq. My lord, this Nazrul Islam, Khairul Islam, and Mujammil Haq. Thereafter, your lordship may kindly come to page 28, my lord, regarding that inquiry, my lord. Page 28, my lord.
yes,
Page 28, my lord, third paragraph, my lord, that's our allegation, my lord, regarding demand thereof. The allegation remanding the demand thereof monetary transaction with Srimati so and so is found to be false. This statement is confirmed by the EVs Nazrul Islam, Khairul Islam, and Mujammil Haq. The persons, my lord, who were collected money on behalf of the, my lord, accused persons, my lord, as per their statement that these three persons has confirmed that, my lord, there is no such allegation. On the basis of their confirmation, ultimately, my
so
lord,
this
yes.
inquiry is not reliable.
Well, because these are the persons who collected
Okay.
money on behalf of
Now,
the-
suppose she coordinates in, do you require her custodial?
difficulty is because allegation is of corruption, maybe. HIV positive.
Okay, heard Mr. A. Chaudhary, learned counsel for the petitioner. Also heard Mr. P. Bhattakur, learned additional public prosecutor. This application under section 482 of BNSS 2023 has been filed by the petitioner Pallavi Saikia. Petitioner namely Pallavi Saikia, who is apprehending her arrest in connection with Nagaon PS case number 796/2025 under section 61 within bracket 2/316 within bracket 5 of BNS 2023. The gist of accusation in this case is that on 8/10/2025, the additional district commissioner within bracket education Nagaon had lodged an FIR before the senior superintendent of police Nagaon, making allegations of corruptions and malpractice against the present petitioner in the recruitment process of the educational volunteers under Laukwa Education Block. It has been alleged that prior to lodging of the FIR, one Zakaria Ali Ahmed had made a complaint against the present petitioner before the executive director of Samagra Siksha Mission, Assam, inter alia alleging that the petitioner, through her close associates, collected 10,000 rupees from the said Zakaria Ali Ahmed, who was appointed as education volunteer in the year 2024-2025. Learned counsel for the petitioner has submitted that the allegations made by the complainant Zakaria Ali Ahmed in his complaint dated 4/8/2025 against the petitioner are not true. He submits that the petitioner is in no way involved in the recruitment process of the education volunteers. He submits that the process of selection of educational volunteers are given in the letter dated 26/9/2024 by the additional district commissioner District Mission Coordinator SSA to the block mission coordinators of various education blocks. And as per the said guidelines, no role is there of the petitioner who is presently engaged on contractual basis as DQM. What
Right.
is DQM?
District Quality Management, my lord. Identity card page 17.
DQM. Stop. He further submits that the petitioner is also is a patient of congenital heart disease and was recently operated in Narayana hospitals for the said ailment. In support of his submission, he has submitted the medical documents of the, where is that discharge certificate?
Lordship.
Medical
Yes, my lord.
discharge certificate
First, GMC is 42 and my lord that Narayana, it is my lord
from the concerned hospital. Stop.
6.
On the other hand, learned additional public prosecutor has submitted that since the allegations of corruption has been made directly by the complainant against the present petitioner, the case diary may be called for. He also opposed grant of any interim relief at this stage. Stop. Let the case diary be called for. Let this case be listed on 26th of November. However, in the meanwhile, considering the medical condition of the petitioner as well as submissions made by learned counsel for the petitioner as discussed in foregoing paragraph, the petitioner, the above named petitioner is directed to appear before the investigating officer of Nagaon PS case number 796/2025 within a period of 7 days from the date of this order and cooperate in the investigation. Stop. If she does so within the stipulated period, in the event of her arrest in connection with the aforesaid case, he shall be allowed to go on interim bail of his 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions 1 and 2. List accordingly.
Much of it. But that is page 43, my lord. Second one, much of it.
Now, here the case is registered under section 366A. Well, a charge sheet has been filed, my lord. The case is registered at Bilasipara. I am from my lord, Dorong, Dolgaon. Now, I want to appear before the court, my lord. Before that, my lord, without declaring me absconder, my lord, they have filed a charge sheet. In the charge sheet, one very interesting statement is given by the victim herself. My lord, page 25 is the charge sheet.
IPC. IPC, sir. You have received summons.
We have received someone, my lord, second time. The date is fixed on 20 of this month. So I want to appear there. And the statement of the victim is very much clear. She herself went with me, my lord, at that point of time because she was forcefully married off to another person.
Then why have you approached this court?
My lord, because if I went to Bilasipara court, I have the apprehension that I will be arrested.
What is the basis of that?
My lord, basis, my lord, this, if I may take your lordship to page 25 of the charge sheet. The last paragraph.
No, which court has issued the summons?
Bilasipara court, my lord.
So that court is competent to grant you bail. 366A,
But
10
when,
years only.
there are judgments, my lord, when there is apprehension, clear apprehension in the mind.
Apprehension has to be must have some basis.
Because of the charge sheet, my lord, the statement, if I may take your lordship in the charge.
That apprehension will be applicable to this court also. If
Yes.
you are apprehending that that court may not grant bail on
No,
the
my
same
lord, I
ground.
am not apprehending that, my lord. I am apprehending that if I go there, my lord, I will be arrested by the police.
Police will not arrest you
Or
once
inside
charged.
the court, my lord, then the court will send me to custody. Because I was not there during the time of investigation.
No.
I have not been declared absconded
How
also.
police can arrest you after
My lord,
submitting
with the
the charge?
direction of the court, my lord, I will be sent to judicial custody.
No, you have to approach the trial court.
But if I may take your lordship to the charge sheet. Once
You
for-
convince the trial court. Trial court is competent enough
But
to,
before convincing, my lord, I will be arrested, my lord.
no.
That
Why-
once I
Why,
appear there, I will not be able to, my lord,
why are you apprehending so?
but there is a apprehension, my lord, because I am not from Bilasipara, I am from Dorong, my lord.
But
And
there is no pending warrant against you.
there is no pending warrant, my lord.
Court has
because-
issued summons. Do you think that after issuing court will, without allowing you to appear before the court, it will direct your arrest?
Practically it happens, my lord.
When?
Practically it happens.
No.
My lord, we are experiencing, my lord, such kind of, my lord, arrest, my lord.
No.
That's why, my lord, there is a clear apprehension, my lord. Charge sheet, if I may take a lordship to the charge sheet, page 25, for a moment, my lord.
Yes. You have to convince the committal court. Yes, show me what they want to show.
Third paragraph.
You may have a good case. Therefore, there is lesser apprehension of
My lord, before I can prove my, my lord, this innocence before the court,
There is- there is
I will be
no-
sent to, my lord, custody.
there is no basis of this apprehension.
But there
this
is no
is a-
bar also, my lord, for this honorable court to grant me, my lord, bail under section 438, my lord. But Supreme Court has time and again has said, my lord, when
But
there is
there has to
apprehension,
be, there has to be genuine apprehension.
my lord, for me, my lord, there is a genuine apprehension. For,
This court will decide whether that apprehension is genuine or not.
my lord, for that, my lord, the charge sheet may be read, my lord. For a moment, my lord. Third paragraph, my lord.
Yes.
The said refusal form has been tagged along with the medical requisition form and kept on record. The section
Page number?
125, my lord. Annexure 2 is the charge sheet.
Which paragraph you are reading?
Third paragraph.
During investigation.
During investigation, the complainant along with the victim were questioned and their statement was recorded in writing and it has been kept with the record. Upon the victim's school certificate being produced by the mother, the same was seized by us in presence of witnesses. And a Jimmanama was made for the mother for the school certificate in presence of other witnesses. The place of occurrence has been investigated and a rough sketch map of the place of occurrence has been drawn up and kept in record. Statement of other witnesses has been reduced in writing and the same has been kept with record. The victim was sent to Dhubri Medical and Hospital for her medical examination. However, the victim
Which para you are?
next paragraph, my lord. This said starts
Yeah.
with this said refusal
This is
form
not third paragraph. This is fifth paragraph.
from here, my lord, yes. This said refusal form has been tagged along with the medical requisition form and kept on record. The section 164 CRPC statement has been recorded before the Honorable Court Bilasipara. The victim herself in her statement 164 CRPC statement before the Honorable High Court. Honorable Court states that on 15/10/23, she on her own volition went with the accused for his elder sister's residence. On 20/10/2023, the police bring her back. She had no physical relationship with the accused. She herself went with the accused on her own accord and she was not coerced by the accused. She has been living with Abdul Jalil for last 4-5 months, her uncle, my lord. Her maternal uncle said that he would marry her off based on the statement of the witnesses as well as the victim. There is
Has been filed by the petitioners, namely 1, 2, 3, and 4. Impugning the judgment and order dated 11/8/2025, passed by the Court of Learned Session Judge Bongaigaon in criminal appeal number 18 within bracket 2/2017, whereby the conviction and sentence imposed on the present petitioner under section 325/34 of the Indian Penal Code by the trial court, that is the Court of Learned Additional Chief Judicial Magistrate, Bongaigaon in GR case number 434/2013 was upheld. Learned counsel for the petitioner submits that the finding of the trial court as well as first appellate court, to the extent that the petitioners were found liable under section 325/34 of the IPC, is perverse, as there is no material on record justifying the conviction of the, as according to him, there are no materials on record justifying the convictions of the petitioner under section 34 of the Indian Penal Code. Stop. Issue notice to the respondent number 2 and call for the records of the trial court as well as the first appellate court from the concerned court. The petitioner shall take steps for issuance of notice upon respondent number 2 by speed post within 7 days from the date of this order, returnable after 4 weeks. Anything else?
Lordship, I am on bail. I may be allowed to remain on the previous remand.
Learned counsel for the petitioner has submitted that the petitioners are on bail granted by the which court?
CJM court, additional chief judicial magistrate.
Granted by the trial court, and prays for continuation of this said bail during the pendency of this criminal revision petition, and also prays for stay of execution of the sentence imposed on them by the impugned judgment. Stop. Since the sentence imposed on the petitioners is a short-term sentence of 3 years only, hence the prayer for interim relief is granted. The execution of sentence imposed on the petitioners by the impugned judgment shall remain stayed during the pendency of the instant criminal revision petition. Stop. The petitioners are also allowed to remain on the previous bail granted by the trial court during this period, subject to one additional condition, that on this condition that in the event of dismissal of the instant revision petition, they shall surrender before the trial court to serve out this remaining part of the sentence imposed on them, placed accordingly.
May I? Please?
Yes.
Not here in this case, I have challenged order at page 18, framing charge against the present petitioner under POCSO, section 4 of the POCSO. Here, what happened in this case, my lord? By page 18, along with 65(1), section 4 of the POCSO Act, charge frame under. So I am agreed by the framing of charge under section 4 of the POCSO Act, not 7665.
4 is
POCSO. And the entire
penetrative.
penetrative sexual assault.
Okay.
Here, my lord, the entire order is challenged on the ground that it is passed by the special court, and he has no authority to pass this order. So on that, he has passed the, I have challenged the entire order.
What no, why no authority?
I am coming, let me. The otherwise, section 4, the FIR was lost. Your lordship will find the FIR. Just I am going to do page 25. Page 25, on the basis of this FIR, a case was registered. Page 25. Right, that's down. A case was registered, very short FIR. May I read?
Yes, you can tell me the gist.
Yes. So on the basis of 25 FIR, the case was registered under 76-65-1, read with 4 of the POCSO Act. Am I clear?
Yes.
Thereafter, the police investigated the matter. And after investigation, your lordship will find, again start from beginning.
Yes, you want back that citation?
Keep it in remaining the record.
Keep it in record.
I have my one copy. I am obliged.
We have, please, your lordship. We have filed petition against the dismissal of our appeal, lordship, NIA, in the Learned Court of Learned Sessions Judge Borpeta. 138.
What are the grounds?
Lordship, grounds we have given, lordship.
Heard Mr. P.K. Das, Learned Counsel for the petitioner. This application under section 438/442 of BNS has been filed by the petitioner Vivekanand Das, impugning the judgment and order dated 18/7/2025 passed by London Session Judge Borpeta in criminal appeal number 2/2023, whereby the judgment and order dated 26/12/2022 passed by London Judicial Magistrate First Class Borpeta in NI case number 172/21 was upheld. Stop. By the impugned judgment of the trial court, the present petitioner was convicted under section 138 of NI Act, Negotiable Instrument Act, and was sentenced to undergo simple imprisonment for 6 months and to pay a fine of compensation of rupees 8 lakhs to the respondent number 2. Issue notice to the respondent number 2. The petitioner shall take steps for issuance of notice upon respondent number 2 by speed post within 7 days from the date of this order, returnable on 16th of December 2025. Let also the records of the trial court as well as First Appellate Court be called for the registry to take steps for issuance of for requisitioning the aforementioned records. Yes, any interim?
Lordship, we have filed an IA also for suspension of sentence.
You have paid anything?
No, we have not paid.
You pay 20%. You are ready to deposit 20%.
Yes.
Stop. In the meanwhile, considering the grounds taken by the petitioner, you are on bail.
No, yes, lordship.
Presently, you are on bail.
Presently, lordship, after the said dismissal of our appeal, lordship, the records were remanded back to the trial court, lordship, and thereafter, lordship, NBW was issued against me. Also. Regarding my appeal.
Kalika,
That is 29.
the grounds taken by the petitioner. The execution of sentence imposed on the petitioner by the impugned judgment is stayed during the pendency of the instant criminal revision petition, subject to condition that the petitioner shall deposit 20% of the amount which he was directed to pay as compensation within bracket, that is rupees 8 lakhs, before the registry of this court or before the trial court. Before the trial court within when?
Period of 2 months, Lordship.
1 month, 4 weeks.
Lordship, 20%, therefore, Lordship, asking 2 months.
Within a period of 4 weeks from the day, you will not be arrested also. Within the period of 4 weeks from the date of this order. Stop. Subject, the petitioner is also allowed to remain on bail of rupees 50,000 with one surety of like amount, subject to the satisfaction of learned trial court, that is judicial magistrate first class Borpeta, in NI case number 172/2021, subject to his payment of 20% of the awarded amount, 20% of the compensation amount as directed herein before, and also subject to the condition that in the event of dismissal of this criminal revision petition, he shall surrender before the trial court to serve out the sentence imposed on him by the impugned judgment, list accordingly.
If possible, 6 weeks. 2 weeks.
6 weeks. 4 weeks or Jagat 6. Okay.
Deeply obliged.
Item 15.
No. In view of, I had the book, in view of the order pass, in view of the fact that the order regarding interim relief has already been passed in the main case, criminal revision petition, this interlocutory application is disposed of. Yes.
Jima petition, your lordship, on the vehicle, your lordship, to desire. The contraband were recovered, your lordship, from the vehicle, but the petitioner is not the accused person, and she is the widow also, your lordship.
Jimma of what?
Lordship?
Jimma of vehicle. Vehicle. You have produced the report.
The meanwhile, my lord, the additional affidavit is filed by the petitioner, my lord. And where, my lord, it is stated that it is already being substituted, my lord. So, my lord, that is from we need the record pen, my lord. So this is the CD part which is available, my lord. Otherwise, I have gone through the available record, my lord. As per the record, my lord, one, my lord, Jimma petition was moved, my lord. Before the, my lord, the special judge, my lord, NDTS, where, my lord, one order is there, I have flag mark, my lord, that is order dated 27/8/2025, my lord. In the record, my lord, that order is there, my lord.
What order?
My lord, regarding the Jimma of the said vehicle, my lord. That, my lord.
By the trial court?
Yes, my lord, that the petition was moved, my lord. That is, my lord,
Page
that
number 19.
was rejected, my lord, after perusal of the report, my lord. My lord, may kindly peruse the order, my lord.
That order has been impugned in this case.
My lord, that is there, my lord. But, my lord, as because it is Sarsitis file, my lord, they have filed additional affidavit, my lord. And, my lord, entire, my lord, there is a record may be called for, my lord. Then we can go through that, my lord.
Already investigation is completed, your lordship. First it submitted, I have filed the additional affidavit. This is the real owner, your lordship. I have submit the RC on page number 18. The lady.
Okay, we'll give a short date calling for the scan copy of the
Yes,
report.
my lord.
No, that was for heard Miss A.M.A.D. Learned Counsel for the petitioner. Also heard Tutul, helicopter, yes. Also heard Mr. A. Basho, Learned Additional Public Prosecutor. It is submitted at bar that though a report was called for from the investigating officer, however, in this case, charge sheet has already been laid and to that effect, an additional affidavit has been filed by the
Petitioner.
petitioner in this case. It is also pointed out by learned counsel, learned additional public prosecutor that this was after filing of the charge sheet. That the scan copy of the records of the special NDPS case number. What is the special NDPS case?
RC submitted on 30 September 2022.
In connection with my lord, delay PS case number.
Special
40 of-
NDPS case which has been registered in connection with Delay PS case number
40/25.
40/2025 be called for. Stop,
CS number is 44/25.
stop. Considering the submissions made by learned counsel for the petitioner, let the scan copy of the case diary is not there, no?
Case diary part. is
Scan
not available.
copy, scan copy of the case diary of Delay PS case number 40/2025, along with the scan copy of the connected NDPS case and scan copy of the charge sheet submitted, charge sheet number 44/2025 be called for from the trial court. Registry to take steps for requisitioning the scan copy. When can we fix?
In the meanwhile, my lord,
Last-
search sheet is
last
filed, my lord. Because of that reason, my lord, 39/25, my lord, the search sheet was filed.
So the date 26, let this case be listed on 26/11/20. No, after submission of charge sheet has been recently submitted. So we are calling for records from the trial court.
Okay.
May I plead your lordship? Lordship, including order dated 30/8/2025, page 23. Page 23.
Yes,
In this case, Lordship, 3825 is the appearance date of the accused petitioner before the learned trial court, Lordship. And consider he is not appeared, Lordship, when the trial court issued the non-bail warrant of arrest against the petitioner.
then what should this court do?
Given on next date, 16/12.
No,
I
you,
will appear, Lordship.
you appear. When is the date?
16/12/2025.
Okay, let him appear.
Yes.
Till then, only till then we will stay the. Why you could not appear?
There's some previous condition, Lordship.
Summons, you received summons earlier.
Yes.
What physical condition?
The high favor, Lordship. Yes. I will appear on the next date, but some protection may be given, Lordship.
Heard Mr. M. A. Mandal, learned counsel for the petitioner. Also heard Mr. M. P. Goswami, learned additional public prosecutor. This application under section 528 of BNSS has been filed by the petitioner, namely Qasem Ali, who is impugning the order dated 38/2025 passed by the Court of Learned Special Judge Bongaigaon in Special POCSO case number 45/2025, whereby non-bailable warrant of arrest were issued to the present petitioner. Learned counsel for the petitioner submits that though the petitioner received summons from the trial court in the aforesaid case, however, he could not appear on the fixed date as he was suffering from high fever. He further submits that next date of the case is, and next date of the aforesaid case is listed on, is fixed on 16/12/2025, and the petitioner is ready to appear before the trial court on the said date and cooperate in the trial. Stop. However, he submits that as a pending non-bailable warrant of arrest is there against the petitioner, some interim protection may be granted so as to facilitate his appearance before the trial court. So, considering the submissions made by learned counsel for the petitioner, as well as considering the fact that the petitioner is ready to appear before the trial court and face trial, stop. This criminal petition is disposed of with a direction to the petitioner to appear before the trial court, appear before the Court of Learned Special Judge POCSO in Special POCSO case number 45/25 on the next date fixed, that is on 16/12/2025. Stop. To facilitate his appearance before the trial court, the non-bailable warrant of arrest issued against him by the trial court shall remain suspended till the next date fixed, that is 16/12/2025. Stop. On his appearance before the trial court, the petitioner may seek any appropriate relief before the said court to which he is legally entitled to, if so advised. This criminal petition is accordingly dismissed.
So this is the 528 petition for quashing of a CR case, my lord, which has been registered pursuant to filing of a final report. In this case, my lord, almost every stage of the case, my lord, almost every order is an illegal order, my lord. I'm saying almost because barring the, my lord, routine orders, all other orders where some reasons had to be given, those are incorrect. Your lordship will first kindly come to page 25.
Just
Page 25 is the FIR.
Which order you are impugning?
Impugning, my lord, multiple orders, my lord. I'm just giving a background, my lord.
Okay,
Page 25, an FIR is lodged by the respondent number 2 against the 2 petitioners, my lord, and other persons who have not been identified. The police registers the case, my lord. After investigation, at page 26, my lord,
what was the accusation?
accusation was, my lord, that the petitioners, along with unknown persons, my lord, had attacked the house of one Kanu Das, my lord, where the respondent number 2 and some other persons, my lord, received minor to major injuries, my lord. Now, this was FIR was registered under sections, my lord, 329, 115, 117, 304, subsection 2 and 35. The police investigates the case. At page 28, police files a final report, my lord. In this case, till here, my lord, it is okay. Police files a final report. Now, pursuant to the filing of the final report, my lord, it's from here the problems start. Lordship will kindly come to page 36. As is required, my lord, after filing of the final report, the learned CJM Karbi Anglong issues notice to the informant, whether the informant has any objection or not. Now, at page 37, informant comes and files a protest petition against the final report. Now, the first impugn order, your lordship will find at page 39. May I read this order, madam?
Yes.
Informant so-and-so is present and submitted a protest petition number so-and-so stating that he has objection in acceptance of the FR submitted by the IO and he is willing to continue the case from his own as a complaint case. Seen Peru's case record heard. Thus, in view of the objections raised by the informant and grounds shown thereon, I am of the opinion that the informant should get a fair opportunity to prove his case by adducing evidence. Now, next time, accordingly, the FR stands rejected. Hence, let it be registered as a complaint case, making relevant entries in the complaint register, transferred to the case of learned so-and-so for necessary order. So, my lord, when an FR is filed, my lord, there are 3 options available before the magistrate. Either the magistrate can reject the FR, take cognizance, and then the case proceeds as a police report case. Or the magistrate can direct a further investigation. Third option is the magistrate can accept the final report. Now, when a final report is accepted, because it may be prejudicial to the informant has a right of filing a protest petition. And if the protest petition is in the form of a complaint, then a complaint case can be registered. But that can only be done after acceptance of the final report. Here, what the learned magistrate does is the learned magistrate, well, I'll place the authorities on these points. The learned magistrate rejects the final report. So for rejection,
But does not accept the police, the charge sheet, the final,
does not accept
does not take up say case on police report.
police report case. And for that also, for the magistrate to reject the final report, the magistrate has to satisfy himself that there are sufficient grounds or sufficient materials. In that case, the magistrate can reject the final report, take cognizance, and the case will proceed as a PRC case. Now, when the magistrate wants the case to proceed as a complaint case, that can only be done after acceptance of the final report. The reason behind is that the police report case has to culminate, it has to come to an end. And because the informant would have himself anyway filed another complaint case. So just to bypass the circuitous procedure, this option has been given that he can file a protest petition. And if the protest petition fulfills all the requirements of a complaint, then the protest petition can be treated as a complaint and a complaint case can be registered.
So here the anomaly is that
The first anomaly is-
without accepting the FR,
Yes, let the case registered a complaint case, my lord.
Hmm.
So rejection, either if FR is rejected, then has to be a police report case, and that too with a finding that there are sufficient materials. Otherwise, it has to be accepted. Now, my lord, will come to the next page, page 40. I've given all the orders, my lord, everything on record I have in it. Page 40, this case is made over to a learned magistrate. Magistrate records the registration of the case and case is fixed for appearance of the complainant. Now, next date, my lord, at page 41. Because now under the scheme of the BNSS, in a complaint case, before taking cognizance, the magistrate has to issue a pre-cognizance notice to the prospective accused persons in terms of the proviso to section 223. So here, the magistrate does that. The magistrate issues a notice to 2 persons, the 2 petitioners, my lord. It fixes the next date for hearing on the point of cognizance. Next date, the petitioners are absent, my lord. Now thereafter, page 43. This is, today the case is fixed for hearing of the accused persons on the point of cognizance. Complainant is present, accused persons are present, and stand represented by their learned counsel, learned engaged counsel. Heard the accused persons on the point of cognizance. According to the accused persons, the complainant has falsely implicated them in this case, and they have no fault in on this. Fix so and so for initial statement. Now the petitioners have raised a plea. The plea may be frivolous, the plea may not be maintainable, whatever be the plea, my lord, there is a salutary purpose for incorporating the proviso that the petitioner, the accused persons have been given a opportunity of hearing. Now, when a petitioners have taken a plea, there has to be an order on the plea, my lord. There's no order on the plea. Magistrate has recorded that this is my plea and straight away fixes the case for the initial statement of the complainant. Now, my
What
lord,
was their contention and why it was rejected?
that is not there.
That is not.
Contention is written that they have raised is falsely implicated. The learned magistrate could have said that this is not a matter which could be decided at the precognizance stage. That could have been done. But even for that, there has to be an order. Reason for either rejecting or accepting my plea. That is not that there. Now, page 44, the statement of the complainant is recorded, madam.
This your application is under what provision?
528, madam, for quashing of the entire proceedings. Page, my lord, 44, complainant statement is recorded. Page 45, my lord, the complainant seeks an adjournment for producing further, submits a list of witnesses, my lord. Now, page 46, this is also important. Here, my lord, the pursuant to that order of the earlier order, my lord, the inquiry is done and the statements of 2 witnesses are recorded. Now, your lordship will come to the 5th paragraph. However, given the nature of allegations,
Page.
page 46, my lord. Lordship has it, my lord?
Yes.
The statements of CW1 and CW2. So the inquiry witnesses are examined, my lord. Now, however, given the nature of allegations, I find it appropriate to direct the complainant to produce other witnesses before the court on the next date. So the court is not satisfied with the statement of these 2 witnesses. Court deems it fit that other witnesses need to be examined before deciding whether to issue process or not. Now, next day, my lord, page 47, the magistrate is on leave. Thereafter, my lord, I will kindly come to page 58. This is the summoning order. So on the last order, the magistrate says that I need to examine more witnesses. Now here, case is fixed for further inquiry, necessary order. Complainant is present and stands represented by his learned counsel. Heard and peruse the case record. Upon perusal of the case record and on basis of the initial statement and the statement of witnesses, I find sufficient grounds to issue summons against the accused persons, issue summons to accused persons, complainant to take steps. So the learned magistrate goes back on the earlier order, where the learned magistrate had recorded that other witnesses need to be examined. Now, no new witness gets examined. And strangely enough, my lord, when the court issues the summoning order, my lord, at no stage of the proceeding, the court has identified the offenses in respect of which the court has decided to take cognizance. The court does not even identify who the persons are in respect of which the court has issued the summons. We have come because we have received the summons. The original FIR, if your lordship remembers, the original FIR mentions
Unknown person.
also mentions unknown persons. So we do not know against whom this court has decided to issue summons. We do not know in respect of what offense the court has taken cognizance, my lord. So it starts from the rejection, that final report order, my lord, goes through till the summoning order, my lord. At every stage where the learned court was required to apply its mind, my lord, there has been abject non-application of mind.
What is the remedy?
Remedy, your lordship, this matter needs to be remanded back to the stage of filing the protest petition. That is one option. Otherwise, your lordship can also quash on the ground that the way.
No, what is the error?
Error is
Wrong of the complainant. How complainant is at fault?
Complainant will be at fault on the ground. I have the authorities on that point also. When the complainant comes and files a protest petition, my lord, then that complainant is also under the responsibility of ensuring that the protest petition is in the form of a complaint. So if the protest petition does not fulfill the requirements of a complaint as defined under 2H of the BNSS, my lord, then the protest petition cannot be treated as a complaint. So that is also, my lord, also come to the complaint petition. First, your lordship, I am relying on these 3 judgments, my lord.
On what point?
On the point of final report, the procedure which has to be adopted.
Okay. Okay, then say that is accepted.
Hello.
That the options which were available for the trial court. It exceeded without, at the one, on the one hand, it rejected the FR, but it allowed the protest petition to be converted into a. So if, is there any specific observation that when when the FR is accepted,
Protest petition can only be treated as the complaint case can only be registered on a protest petition
when it is
after acceptance of the final report.
that,
That is there, man.
where is that?
My first, your lordship will kindly come 3 judgments, my lord. It will be a short judgment, my lord. First, Bhagwan Singh, my lord, there is the first judgment on FR. That your lordship will kindly come to para 4.
Yes.
Now, when the report forwarded by the officer in charge of a police station to the magistrate under subsection 2(1) of section 173 comes up for consideration by the magistrate, one of two different situations may arise. The report may conclude that an offense appears to have been committed by a particular person or persons, and in such a case, the magistrate may do one of 3 things. He may accept the report and take, this is in case of a charge sheet, my lord. He may accept the report and take cognizance of the offense and issue process, or he may disagree with the report and drop the proceeding. Or 3, he may direct further investigation under subsection 3 of 156 and require the police to make a further report.
He may disagree with the report and
He may disagree with the report and drop the proceeding. This is in case of a charge sheet. There will be 2 options, either it is a charge sheet or a final report. So in case of a charge sheet, these are the 3 options. The next line, this my lord, gives the law regarding final report, my lord. The report may, on the other hand, state that in the opinion of the police, no offense appears to have been committed. And where such a report has been made, the magistrate has the option to adopt one of 3 courses. He may accept the report and drop the proceeding, or he may disagree with the report and taking the view that there is sufficient ground for proceeding further, take cognizance of the offense and issue process, or he may direct further investigation to be made by the police under subsection 3 of section 156. Where in either of these 2 situations, the magistrate decides to take cognizance of offense and to issue process, the informant is not prejudicially affected, nor is the injured or in the case of death, any relative of the deceased aggrieved, because cognizance of the offense is taken by the magistrate and it is decided by the magistrate that the case shall proceed. But if the magistrate decides that there is no sufficient ground for proceeding further and drops the proceeding or takes the view that though there is sufficient grounds for proceeding against some, there is no sufficient ground for proceeding against others mentioned in the first information report, the informant would certainly be prejudiced because the first information report lodged by him would have failed of its purpose wholly or in part. Moreover, when the interest of the informant in prompt and effective action being taken on the first information report lodged by him is clearly recognized by the provisions contained in subsection 2 of section 154, subsection 2 of 1 section 157, and subsection 2 of section 173, it must be presumed that the informant would be equally interested in seeing that the magistrate takes cognizance of the offense and issues process, because that would be a culmination of the first information report lodged by him. There can therefore be no doubt that when on consideration of the report made by the officer in charge of a police station under subsection 2(1) of section 173, the magistrate is not inclined to take cognizance of the offense and issue process, the informant must be given an opportunity of being heard so that he can make his submissions to persuade the magistrate to take cognizance of the offense and issue process. We are accordingly of the view that in a case where the magistrate to whom a report is forwarded under subsection so and so decides not to take cognizance of the offense and to drop the proceeding, or takes the view that there is no sufficient ground for proceeding against some of the persons mentioned in the first information report, the magistrate must give notice to the informant and provide him an opportunity to be heard at the time of consideration of the report. So this is, my lord,
no, that is okay.
So my lord,
But
now
that-
the next point is.
We will again continue at 2. No, on the point that the acceptance of final report is come to directly to that.
My lord, we'll come to this two judges. First is my lord Chandrika, P. Chandrika,
Ah.
2014, 13
Ah.
FPC, my lord. Paragraph, my lord, para 5. Very short judgment, my lord.
Come directly to
Yes, my
that.
lord, para 5.
Yes.
The power of the magistrate to take cognizance of an offence on a complaint or protest petition on the same or similar allegations, even after accepting the final report, cannot be disputed. It is a settled law that when a complaint is filed and sent to
No,
police.
that does not means that acceptance is a mandatory.
My lord, kindly just bear with me for a minute. my lord.
Okay.
It is a settled law that when a complaint is filed and sent to police under section 156(3) CRPC for investigation, and then a protest petition is filed, the magistrate, after accepting the final report of the police under section 173 and discharging the accused persons, has the power to deal with the protest petition.
Okay.
However, the protest petition has to satisfy the ingredients of the complaint
Okay.
before the magistrate takes cognizance of the offence. The other is, my lord, from this Honorable High Court, my lord, Moinul Haq, my lord, 2013 SSC Online GAU 264, para 9, my lord.
No, apparently otherwise the cognizance taking order is defective. In as much as it does not specify under what provision cognizance has been taken.
In my respectful submission, the entirety of the complaint case goes because the nullity is at the root of the case. The genesis of the case is that impugned order, my lord, whereby the final report was rejected and the complaint was directed to be registered. Irrespective of the fact that whether this terminology rejected or accepted, even if that is for a moment not considered, there are other requirements, my lord, because Bhagwan Singh says, the moment the final report, because state has done its part, what the learned CJM has done is that he has acceded to the wishes of the complainant. The complainant says that I want to proceed with the case as a complaint case, so he has directed the registration of the case. But here the complainant had first invoked the jurisdiction of the state. The complainant had filed an FIR. The state investigated the case. State did its duty.
Okay,
State-
without accepting, he could not have
Right.
gone.
The state did not find anything. State submitted a final report. So now the magistrate was first required to examine the final report. Give reasons. If there were no materials in the final report, he could accept it. If there were materials in the final report, he could reject it. Or if he thought he needed further investigation, he could have directed further investigation. These three steps had to be undertaken. He does not do so. Straight away, he rejects the final report. And the reason is that because the complainant says that I want to proceed the case on
No,
my
he
own.
does not reject.
He rejects the final report, my lord.
Hmm.
He rejects the final report only because
Okay.
the state says that we have not found anything to prosecute, we close the case. Now, if the complainant wants to proceed with the case on his own, the complainant could have filed a complaint case. But when he takes this route of protesting against the
On
protest,
rejection of final report, only one option is available.
it has to go as a
PRC
PRC
case.
case. And that too, he could have.
Subject to material.
material.
Unless there are materials, he cannot reject the final.
Yeah, reject the
Okay.
That is my case, my lord. So when the case goes to the nullity, error goes to the root of the case, the subsequent proceedings, my lord, there is a judgment on to that effect also. When the genesis of any criminal prosecution is a nullity, then the prosecution of the subsequent proceeding goes.
Anything?
Lordship, so far the order is concerned, my lord. Lordship will find when the final report is submitted, my lord. It is as per my lord, it is like a complaint petition. So far I have seen, my lord. But the format has to be in a complaint, my lord, so that he can forward to be registered as a complaint, my lord. So that has been forwarded to the magistrate, my lord. Thereafter, my lord, now my lord, cognizance part, my lord. As per the orders, my lord, there is no cognizance order, my lord. Because now only, my lord, there is the initial deposition taken from the witnesses present from the informant side, my lord. So now the procedure is, my lord, first he will witness, my lord, examine those witnesses, my lord. Therefore, again, my lord, if there are materials against them, he will again summon the accused, my lord. Accused will also, my lord, will be examined.
No, this order dated 18/8/2025 is pre-cognizance order or
No, that's not a
it is
pre-cognizance.
issue.
Summons is a summoning order.
It is, my lord, issue summons to the accused persons, my lord. This is a
No,
pre-cognizance
no,
order.
there is another order. That is at page 41. That is the precognizance. This is not the precognizance order here. 200 has been done, 202 has been done, then summon.
41, my lord, if we see 41.
That is the precognizance.
Hearing on the
complainant-
point of cognizance.
Complainant is, representative is present, hence represented by learned counsel, heard the complaint and perused the case. Issue notice to the accused persons. Complainant to take steps. And now, my lord, 9.5 for hearing the accused person on the point of cognizance, my lord. 29 for last part, my lord.
Page number?
Page number 41, my lord. Last part, Lord, if you may kindly say, fixing 9/5/2025, page 41, Lord. Page 41. So for hearing the accused persons on the point of cognizance, my lord. Till now, that has not been
No, no.
done.
It's 43, sir.
One, my lord.
It's 43, sir. Okay. After that, in page 43, we have been heard on the point of cognizance. So pre-cognizance hearing is done, but no order has been passed
As
in
regards
terms of
the
223 proviso.
It is only after taking cognizance
Yes, ma'am.
yes, initial, my lord.
initial statement has to be recorded prior to
Prior to cognizance.
cognizance.
Yes, my lord. So at no state of the case, my lord, whether after hearing me, whether before recording the statement or after recording all the statement, when the court by the last order, my lord, 18-8 order also, when the court decides to issue summons to me, even at this
204.
stage,
Prior to that, cognizance has to be taken.
taken. So cognizance in respect of which offences that has not been identified, my plea, irrespective of whether it has any merit or not, has not been discussed. No order to that effect has been passed. So the whole purpose of incorporating 223 proviso, that has been done away with. So mechanically, we have been summoned, noticed, we come, court goes to the usual process in terms of the earlier CRPC and decides to issue summons, again without identifying in respect of whom court issues summons and in respect of which offences. These aside, my lord, the original defect, my lord, remains, my lord. The whole genesis. But I have also given a notification of this Honorable High Court because both Chandrika and Moinul Haq, my lord, says that this protest petition also needs to fulfill the ingredients of a complaint, my lord.
Yes.
So your lordship will see this notification whereby our High Court criminal rules and orders have been amended. Lordship will kindly come to the 5th page, my lord. B form, my lord.
Yes.
So this is the prescribed from in terms of the Guwahati High Court criminal rules and orders. Apart from specifying the cause of action, status of the complaint, the lordship will come to the next page. It requires an affidavit, it requires a verification. This is what has been mandated by this Honorable High Court in terms of its rule-making power.
Where the complainant defaulted,
My lord,
where he
Yes.
is at fault.
in that respect, my lord will kindly come to the protest petition that your lordship will find at page 57.
Okay, we are issuing notice.
So my lord, my humble prayer is that proceedings may be stayed.
Heard Mr. S. Nawaz, learned counsel for the petitioner. Also heard Mr. M.P. Goswami, learned. Sorry. Additional public prosecutor. This application under section 528 of BNSS 2023, read with article 227 of the Constitution of India, has been filed by the petitioners, namely Sanjay Hajorika, number 2 Kapil and Kapil Hussain, alias Mohammad Kafil Hussain, praying for quashing of the proceedings of CR case number 6/2025, pending in the Court of London, Judicial Magistrate First Class, Karbi Anglong. The learned counsel for the petitioner has submitted that on 23/1/2025, the respondent number 2, that is one Prosenjit Das and three others had lodged an FIR before the officer in charge of Difu police station, inter alia, alleging that on the prior day of filing of the FIR at about 10:30 PM, the present petitioners and accompanied by other goons attacked the family members of the first informant at the residence of one Kanu Das located at Panbari locality. No, attack the petitioner Nokobo. Attack the family members of one Kanu Das at his residence. So, on receipt of the said FIR, Difu PS case number 5/2025 under section 329 within bracket 3/115 within bracket 2/117 within bracket 2/304 within bracket 2/3 within bracket 5 was registered and investigation was initiated. Ultimately, on completion of investigation, the police YFR was found no evidence from.
Two grounds, my lord. One is no information could be obtained about the whereabouts of the accused persons, and no other witnesses were found. No evidence could be furnished.
On completion of the investigation, due to lack of evidence against the present petitioner, the investigating officer submitted the final report bearing FR number 05/28 05 dated 28/2/2025. On receipt of the final report, the trial court issued notice to the first informant, that is respondent number 2, who filed a protest petition against the submission of final report. Learned counsel for the petitioner has submitted that the trial court, that is the Court of Judicial Magistrate First Class,
Chief Judicial Magistrate.
Chief Judicial Magistrate Karbi Anglong, by order dated order dated 8/4/2025, passed in
CR number.
passed in CR case number 6/2025. After going through the final report, rejected the final report. However, at the same time, it directed the registration of the protest petition as complaint case before and transferred the said complaint case to the Court of Learned Judicial Magistrate First Class, First Class Karbi Anglong. learned counsel for the petitioner has submitted that the said order dated 8/4/2025 is an illegal order in as much as without accepting the final report submitted by the investigating officer, the trial court could not have dealt with the protest petition. Stop. It further submits that in the case of rejection of the final report, the only option which was available to the court was to register a PRC case if the final report otherwise discloses commission of offense against the petitioner, offense as complained. Stop. He submits that it is only after acceptance of final report the court gets power to deal with a protest petition, and if protest petition discloses an offense, and further if it is in the form as prescribed by the High Court, the said protest petition may be registered as ACR case, which was not done in this case. In support of his submission, learned counsel for the petitioner has cited a ruling of the Apex Court in the case of B. Chandrika versus Santosh and another, reported in 2014-13 SCC 699. Learned counsel for the petitioner has further submitted that in this case, though at the stage of pre-cognizance, at the stage before taking cognizance, while dealing with the CR case number 6/2025, the notice were issued to the petitioners, and they also were given opportunity to where is that order?
My lord, at page 43, my lord.
Opportunity to make their submissions. However, the plea taken by the present petitioners against the protest petition, which was registered as complaint case, was not discussed by the trial court, and after an initial statements were recorded of the complainant's witnesses. He further submits that on 3/7, by order dated 3/7/2025, after recording the initial statement of two witnesses, namely CW1 and CW2, the trial court felt it necessary to examine other witnesses of the complainant, considering the nature of the accusation made. However, after a few dates, without examining any further witness, the trial court issued summons against the present petitioner, finding by making observation that there is sufficient ground to issue summons against accused persons. learned counsel for the petitioner submits that the order dated 18/8/2025 is in fact an order of taking cognizance by the trial court. However, same also suffers from defect in a,
Not be my submission.
Huh?
Say,
Huh?
Because my lord, 18/8, we have not said that 18/8 is an order of cognizance. Because my lord, the law otherwise is settled that cognizance is only taken.
no,
in
it
the
is
case-
apparently a cognizance, order of cognizance without mentioning under what provision cognizance.
We have
Now, what is
projected
your
it-
submission?
Our projection is that this is a summoning order without identifying the offenses because cognizance is taken my lord, before
Oh,
issuance of summons.
okay,
So summon, in a complaint case, cognizance is taken only when 200.
last line continue. Learned counsel for the petitioner submits that by order dated 18/8/2025, those the court observed that sufficient grounds are there to issue summons against the accused persons. However, no specific mention was made in the said order as to under what offenses materials were found sufficient, as to in respect of what offenses materials were found sufficient against the petitioner. Neither it has been mentioned against which of the accused persons the summons were issued. He submits that this is important as in the original FIR, apart from the present petitioners, accusations were made against some unknown persons also. So. I have considered this. On the other hand, learned counsel for the learned counsel for the petitioner, learned counsel for the on the other hand, learned additional public prosecutor has submitted that the accused and that the petitioners were heard on the point of taking cognizance, and by order dated 19/5/2025, after considering the plea taken by the petitioners, the trial court decided to proceed further in accordance with law. He submits that there is no error in the orders passed by the trial court in the aforesaid order, in the aforesaid CR case. So I have considered the submissions made by learned counsel for both sides. It appears that neither in order dated 19/5/2025 nor in order dated 18/8/2025, the trial court has stated as to under what, for what offenses sufficient materials were found against the present petitioners. Stop. The order of issuing summons against them without mentioning the specific penal provisions under which sufficient materials were found prima facie appears to be erroneous. Stop. issue notice to the respondent number 2 and call for the scan copy of the CR case number 6/2025 along with the case diary would be available of the earlier case.
Be available in CR case because it could be tagged, my lord, here.
Case diary may not be tagged.
But otherwise, my lord, we are not on that part of
Okay.
that case.
CR case. The petitioner shall take steps for issuance of notice upon the respondent number 2 by speed post as well as by usual mode within 3 days from the date of this order, returnable on 16th of December 2025. So, in the meanwhile, in view of the submissions made by learned counsel for the petitioner as discussed in the foregoing paragraphs, as well as observations made by this court, further proceeding of CR case number 6/2025 shall remain stayed till next returnable day. List accordingly.
I'm deeply operated.
Item 61.
May I please your lordship? This is an application for quashing of complaint petition pending 482 application read with section 528 BNSS Act, praying for quashing of complaint petition 510/23 pending in the Court of Sub-Divisional Judicial Magistrate Court number 2 at Guwahati. And the operative portion in this case, the petitioner and the respondent are a husband and wife, my lord. Their marriage was solemnized in the year 2016, my lord. And the marriage subsists only for 3.5 years because of so many reasons I have stated in my petition. So, under that, at this stage, my lord, the page 17 operative portion is para 2. Page 17.
No, on what ground you are seeking quashing? What was the accusation, allegations?
My lord, the allegation is that his main ground is that on 6/9/23, both husband and wife, they lost an FIR before Dispur police station, my lord. That will be evident from page 17. Operative portion is para 2. Page 17, para 2.
No, what is the allegation in the complaint case?
The allegation is, my lord, that was taken, cognizance was taken 294,
No,
320.
that is not my question. My question is, what was the allegation? What allegation was made by your wife against you? Some accusation has been made.
Yes, regarding the filing of FIR, this case, the complaint case is arising out of an FIR.
What was the allegation in the FIR?
FIR, that was at page 17, your lordship, in the complaint petition. In the complaint petition, page 17, your lordship.
No, you can tell me what was the allegation.
My lord, the allegation is that on 6/9/23, she went to the house of her husband and for asking due money in DV case number, in DV case, my lord. Already a DV case was pending before the Honorable Court of SDJM 2, Kamrup Metro at Guwahati.
Then you assaulted her.
As per allegation, my lord.
That is the allegation.
She assaulted
just
her
want to-
mother. She assaulted her mother. But fact is not like that, my lord. On 6/9/23, she went to the house of her husband, matrimonial house, for asking his husband to pay the entire amount of DV case, the interim amount granted by the Honorable Court in DV case, my lord. So at least 3 to 4 lakhs of rupees is pending, still he is not paying that. For that purpose, she went to the house of matrimonial house on 6/9/23. And according to the respondent, she assaulted her mother-in-law. But according to the petitioner, she said that she was assaulted very brutally by the husband and the mother-in-law. And thereafter, finding no alternative, she called for 103, 100 dial, and thereafter police came to rescue her. And thereafter, both the accused and the respondent, they taken to the police station. And thereafter, the husband, as per allegation of the husband, her mother-in-law was assaulted on cheek, head, and some other parts. And he also taken her mother to Hayat
Okay,
Hospital for
now
treatment.
your wife,
My wife, I have been,
husband lodged an FIR against you alleging that you have assaulted
mother-in-law.
mother-in-law.
So this much is the allegation. But at the same time, we have also lost the FIR before.
No, what
Dispur
happened
police
to
station.
them? What is this complaint petition 5110?
These are the allegations, my lord. Page 17, my lord. And thereafter, in the complaint petition, he alleged so many things.
What happened to that?
The wife also
Now,
filed
why are
FIR.
you challenging? On what ground you are
My-
challenging?
This complaint petition has been filed with a view to harass the wife
Vengeance.
because she is economically and financially, she is very weak. Her father even died during the pendency of these cases because of shock found from her daughter. So this complaint case has been lost purely to harass the wife only, nothing else, my lord. Because on the same ground, my lord, 2 FIR has been filed before the Dispur police station, and the investigation is still going on, perhaps. But he stated in the petition at page 18, your lordship, page 18, your lordship, that he has filed an FIR before Dispur police station, but Dispur police did not take any action. Thereafter, he filed this complaint case. So that is evident from page 18, your lordship, at para 6.
What is the status of this complaint petition?
My lord, she has no source of income, my lord, at all. She is staying at Swalkusi.
No, that is not my question. Status of the complaint petition, whether summons have been issued,
Yes,
whether
my lord.
cognizance.
That is at page, your lordship, page 51, your lord. 51 to 57. Cognizance have been taken by the court, my lord.
Where is that order?
Page 56, your lordship. Page 56. Order dated 04/12/24. Cognizance of offense under section 294, 323, 447. IPC is taken against the accused Papuri Kolita. So this case is purely fake, false, and fabricated one, your lordship.
That plea you can take before the trial court.
My lord, she is harassing by her husband in such a way, my lord, that multiple cases has been lodged against her. So she is very economically weak and she is financially weak. She cannot even attend the court properly.
Which FIR was filed? You said that in respect of the same offense, the husband also filed a FIR in this.
FIR. Before this.
Where are
police
the
station.
particulars of that FIR?
That FIR is at page, your lordship. FIR. 46. Translated to be responded. Page 46, page 47, your lordship.
Whether any case was registered?
That was not known.
Then. Yes, Mr. Chandra.
Case 46, my lord. FIR was lodged by the husband, my lord, Digit Kumar Butcho, my lord, alleging the occurrence took place on 6/9/2023.
23, man.
At 11 where assaulted his mother, my lord. And after
No,
Right.
apart from, okay. We issue notice.
My lord, in the meantime, my lord, in the interim, your lordship, the operation of the order dated.
Why?
Because my lord, she is appearing court, she has no money to even appear the court. She has a minor son also. Even the husband is not paying a single farthing in the DV case,
That
my
may
lord.
not be a ground for.
My lord,
at this stage, notice may be
interim
issued, my
order,
lord.
Okay.
I have submitted one copy of the DV case and the interim order also. In the interim order, he was directed to pay 10,000 rupees per month with effect from 23. And he is not paying a single farthing till date. How she will survive, my lord? This complaint case is with a motive to harass the wife only. Nothing else, my lord.
Heard
Such
me.
thing was not happened. Nothing was happened on 6/9/23.
Heard.
Even Hayat Hospital, my lord, the
This
if
is item number.
prescription was issued only.
Heard Mr. D.R. Saikia, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 528 of BNSS has been filed by the petitioner, namely Mrs.
Papuri Kolita.
Papuri Kolita, praying for quashing of the
Complaint petition.
ER case number 5110/2023,
My lord,
Pending.
510C.
510C/2023, pending before the Court of Learned, Subdivisional Judicial Magistrate number 2,
Number 2. Kamrup Mehta.
Kamrup Metro. Learned counsel for the petitioner has submitted that the aforesaid complaint case was registered on filing of a complaint case by the respondent who is the husband of the present petitioner, wherein mainly it has been alleged that on 6/9/2023, the present petitioner assaulted and injured the mother of the respondent number 2. Learned counsel for the petitioner has submitted that the petitioner, the respondent has been filing multiple number of cases against the petitioner without any cause of action for the same. He also submits that the petitioner has been directed to pay maintenance allowance to, no, the respondent has been directed to pay maintenance allowance to the present petitioner in
DV case number 103,
DB case number 103
2020.
/2020.
Dated, sir, 19/2/21.
However, the petitioner has not been paid a single penny in the said DB case, in spite of the orders of the court. He further submits that in respect of the same offense, the respondent had lodged an FIR on 6/9/2023 against the present petitioner before the officer in charge of this police station. However, without mentioning the fate of the said notice, said FIR, the respondent has again filed a
Lordship, interruption, my lord, page 18, my lord. Why it was not registered, my lord? Para 5, my lord, page 18, in the complaint petition, my lord, it was mentioned, my lord. Page 18, para 5, my lord. And it was below the, on the available section. It was
however,
for that purpose.
okay,
All of
stop,
available
stop.
section.
That was his submission. Stop. On the other hand, learned additional public prosecutor has submitted that the trial court has issued summons to the petitioner after following due procedural requirements, finding sufficient materials against the petitioner under section 294/323/447 of the IPC. He further submits that
Due respect, may I submit one thing, my lord? If the things are so happen, my lord, why learned may said it is the duty, mandatory provision that he ought to have sought a police report under section 210 of CRPC.
you have yourself stated in your
Yes, I have said in my
petition.
petition.
Kalika lastly. Stop. He submits that in the complaint petition itself, at para number 6, it has been stated by the respondent that why the FIR filed by the respondent was not registered. Respondent number 2 was
Para 5, my lord.
para 5 as to why respondent number 2, why the FIR filed by the respondent number 2 was not registered. Stop. Let the notice be issued to the, when is the next date fixed?
My lord, 21/11.
Let the notice be issued with the respondent. Let the petitioner shall take steps for issuance of notice upon the respondent by speed post within 7 days from the date of this order, returnable on 8th of December 2025. List accordingly.
My lord, if no stay was granted, my lord, she will have to appear, she will have to take bail. No father, even widowed mother, she has no income. Absolutely, my lord, she will be in mass trouble, my lord. So at this stage, my lord, till the returnable date, interim may be granted, my lord.
No. This court is not inclined to grant any interim relief at this stage, as the petitioner has failed to make out a case for grant of interim relief at this stage. We'll appoint one amicus curiae. Heard Mr. Dharakulla, learned counsel for the petitioner. The notice is served.
Regarding death, regarding service. Yes, notice served.
Also, Mr. P. Bhattakur Learned, additional public prosecutor, who submits that notice issued to respondent number 2 has been duly served. Stop. Since this case involves offense under POXO Act,
Yes, sir.
this court is inclined to appoint one amicus curiae to defend the cause of respondent number 2 in this case. Any amicus present in the court? Any amicus? The this court accordingly appoints Mr. N. Mahajan, learned counsel, whose name appears in the list of amicus prepared by registry to defend the cause of respondent number 2 in this case. The petitioner is directed to furnish a copy of bail application along with annexures to the newly appointed amicus curiae within 2 days from the date of this order.
Yes.
Let this, the registry is directed to reflect the name of Mr. N. Mahajan in the cause list as amicus curiae for respondent number 2 in this case. Let this case be listed. Case diary is there.
No,
Here.
Yes, yeah.
Already.
Since the
13.
when should we fix?
13.
You have to furnish
Lordship, we will furnish by today. or
14.
tomorrow. 14. Lord.
14. Let this matter be listed on 14th of November.
Line observation may not be there.
Last line to continue.
Observation.
Last paragraph. Delete it. Okay.
Item 18.
Yes.
My lord, this trial is at the stage of appearance, my lord. I'm one of the accused. My lord, I could not appear on 2 dates, my lord, page 33. On medical ground, my lord, and warrant of arrest were issued, my lord, non-bailable. My lord, I am ready and willing, my lord. I am duty bound. I will definitely.
You were appearing earlier.
No, my lord, actually, I was not served with summons, my lord, but bailable warrant was executed. I was called to the police station and I put my signature and then on the next date, my lord, I could not appear due to medical reasons, my lord. On that day, warrant.
The trial court issued summons to you.
Asked should trial summons to me, my lord, but that was not, I have never received it. But thereafter, when bailable warrants were issued, my lord, police station called me up, I appeared and put my signature there, my lord. And thereafter, on the next date, my lord, I was supposed to appear, I admit, my lord. But due to, I was prevented on medical reasons, my lord, I could not appear. But I'm fully ready and willing, my lord. I'll appear and I'll face the trial, my lord. But at this stage, since the non-bailable warrants are issued, my lord, for that, my lord, I apprehend, my lord. So I pray that, my lord, either it may be kept in abeyance or maybe recall, my lord. And I will, a time may be fixed, my lord, I will definitely appear by then.
When is the next date?
My lord, tomorrow is the last date, next date, but my lord, my lord may give me 10 days, my lord.
Why? You appear tomorrow.
Tomorrow, my lord, certified copy will be available or not for all these things.
Yes.
My lord,
Page 33, my lord. This is the order, my lord.
I admit, my lord, bailable warrants, but for some reason, my lord, I could not understand it properly, and for medical reason, I was prevented, my lord.
What medical reasons?
My lord, that point of time, my lord, has some injury, my lord. At page 35, I had a chronic backache, my lord. I had that problem, that persists, my lord.
Heard. Mr.
T.S. Hajan.
T.H. Hajorika, learned counsel for the petitioner. This application under section 528 of BNSS has been filed by the petitioner, namely Monil Doimari, impugning the order dated 30/8/2025 as well as 25/9/2025 passed by the Court of London, Subdivision Judicial Magistrate, Baksa, in PRC case number 605/2024, whereby non-bailable warrant of arrest were issued against the present petitioner. The learned counsel for the petitioner submits that the petitioner never received any summons from the trial court, though his names were mentioned in the charge sheet. Stop. He further submits that though petitioner was informed about the issuance of bailable warrant, and accordingly he appeared before the police station and was released on bail by the police. However, on the next date fix, that is
25/9,
25/9.
page 33.
on 25/9/25, he could not appear before the trial court as
Both
he
38/2025 and 25/9/25.
on 38/2025 and 25/9. He could not appear before the trial court as he was suffering from ailment. Within bracket, chronic low backache, bracket close. In support of his submission, he has annexed as annexure 4 the medical certificate issued by medical officer of Tamulpur SDCH. Stop. Learned counsel for the petitioner submits that next date of the case is fixed before the trial court on 11/11/2025, and the petitioner is ready to appear before the trial court and cooperate in the trial. However, as non-bailable warrant of arrest have already been issued against him, he seeks some interim protection in this regard. After anything,
Lordship, only the appearance minor. The
Okay.
trial court will decide as per law.
Hmm.
Because it case.
After- considering the submissions made by learned counsel for the petitioner as well as learned additional public prosecutor and this court is of considered opinion that the petitioner, as the petitioner is willing to face the trial, he may be granted an opportunity to appear before the trial court. Accordingly, this criminal petition is disposed of with a direction to the appellant, with a direction to the petitioner to appear before the trial court within 7 days from the date of this order and cooperate in the trial. In order to facilitate his appearance before the trial court, the non-bailable warrant of arrest issued against him by the trial court shall not be executed for next 7 days. Stop. After his appearance before the trial court, he may seek any appropriate relief to which he is legally entitled to, if so advised. This criminal petition is accordingly disposed of.
Your blessing. My lord, may I just make a prayer, my lord? My lord, can I be allowed to appear before a sessions court, my lord, original trial court, because SDGM may not have the, my lord, that part on the.
No, unless your case is committed.
Objection.
Item,
May I please interpret? I, on behalf of my senior, I repeat, my lord, as instructed by my senior, this is a petition for quashing of FIR dated 01/08/2025.
what
Right.
are the grounds?
It was lodged by one Prasanta Pura, the chief editor, Delhi Arkoto Disport, Guwahati, alleging that the petitioner is an Afghan national.
Alleging that
Alleging that the petitioner is an Afghan national.
Page 13, lordship. Will be the FIR.
will call for the case diary.
Only the Scan copy.
No, charge sheet has been laid.
Sheet not laid down.
We'll call for the case diary.
Sheet not laid down.
Heard, Mr. What is your name?
Benze Jantan.
Yes,
Benze Jantan.
write your name in on a piece of so and so. Learned counsel for the petitioner. This application under section 528 of BNSS 2023 read with section 227 of the Constitution of India has been filed by the petitioner Rihan Khan alias Nasir Khan, praying for quashing of the FIR dated 1/8/2025, lodged by the respondent number 2, on the basis of which Latasil PS case number 75/25 was registered. Stop. Issue notice to the respondent number 2. The petitioner shall take steps for issuance of notice upon the respondent number 2 by speed post within 7 days from the date of this order, returnable on 16th of December 2025. Let the case diary be called for.
Yes. Scan copy of the case because investigation is going on now.
Let the scan copy of the case diary be called for. The learned additional public prosecutor shall produce the scan copy on the next.
GP of that.
This is an application under the 428, for quashing the NBW matter. What happened, my lord?
For quashing the
NBW and PNA matter. Impugn order is a page number 30, my lord. What happened, my lord? Someone was not properly supplied. Page number 30, my lord, impugn order.
page number
30, 30, my lord. Ekish Nur Hussain,
why you failed to appear.
my lord, someone was received by my mother. My lord, kindly for a moment, page number 32, my lord.
Thereafter,
My lord, he did not communicate with me, my lord. I was at Karnataka for labor matter. That's why I could not, my lord, appear for the land court. Earlier I was on bail, my lord.
when
I am intending to appear, participate in the trial.
when is the next date?
My lord, 12. 7 days time may be given
No, you appear on 12/10.
on or before. 12.
Heard. Mr. A. Paramanik, learned counsel for the petitioner. Also heard Mr. M.P. Goswami, learned additional public prosecutor. This application under section 528 of BNSS 2023 has been filed by the petitioner who is aggrieved by the order dated 22/3/2023 passed by the Court of Learned Chief Judicial Magistrate Kamrup Metro in PRC case number 3094/2022 under section 22B of NDPS, whereby the trial court the said court has issued non-bailable warrant of arrest against the petitioner and also passed order for proclaiming the petitioner as an or proclaimed offender
Proclamation against accused, my lord.
as well as attachment of his properties. Learned counsel for the petitioner submits that though the trial court issued summons in PRC case number 3094/2022 to the present petitioner. Same was served on the mother of the petitioner, who failed to communicate about the dates of the said case to the petitioner, as he was in Bangalore.
Karnataka, state of
He
Karnataka.
was in Karnataka for earning his livelihood. Learned counsel for the petitioner submits that the next date of the case is fixed on 12/10,
12/12/25.
12/12/2025. And the petitioner is ready to appear before the trial court and face the trial. Now, after considering the submissions made by learned counsel for both sides, as the petitioner is ready to appear before the court to face trial. Stop. This criminal petition is disposed of with a direction to the petitioner to appear before the Court of Learned Chief Judicial Magistrate, Kamrup Metro, Guwahati, in PRC case number 3094/2022 on the next date fixed in the said case, that is 12/12/2025, to facilitate his appearance before the trial court. The operation of non-bailable warrant of arrest issued against him by the trial court, as well as the orders of proclaiming him as absconder and orders relating attachment of his property, shall remain stayed till 12/12/2025. Stop. If the petitioner appears before the trial court on the next date fixed, he may seek appropriate relief before the said court, to which he is legally entitled to. This criminal petition is accordingly disposed.
I live on or before 12/12, my lord. Can I appear before?
On or before 12, instead of
I live.
My lord, on or before 12, then my lord, the interim order till his appearance, my lord, because lordship has stated interim order till 12/12, my lord. So that has to be also.
till 12/12
May I please-
or till his appearance, whichever is earlier.
Lord,
May I please, Lordship? Well, in this case, Lordship, during investigation, the police visited my house, Lordship. After verification, my lord, my lord, are you satisfied that I am not that person against which FIR was lodged, Lordship? Thereafter, matter was investigation, my lord, charge sheet was submitted, my lord, showing that person, my lord, who was son of my lord Noor Muhammad, Lordship. My lord, and showing that person absconder, Lordship. Thereafter, someone was issued, Lordship. That someone was not served, Lordship. During some, my lord, attempt to service of someone, Lordship, verified. The report was, my lord, the Gavura was also there, Lordship. Kindly see at page 19, Lordship. Page 19, Lordship. Order dated 14/11/2019. Accused Mohammed Mintaz Ahmed alias Mafidul is absent. Summons issued to the accused has returned with report that the accused was not found in the mentioned address
it could be learned from the local people that there is no people by this name at that area. The report is endorsed by the Lat Gaura. Seen the report, search sheet also shows accused on as absconder despite home search issue NBWA. My lord, no person was there in the, my lord, available in the, in that area, lordship, by the name who, against whom search sheet was submitted, lordship. Now, I am the, I am the resident of that area, lordship. Now, NBW was issued, lordship, thereafter, lordship. My lord, that matter was inquired, my lord, and my lord, IU submitted that the person was not found available. My lord, no lender, my lord, movable or immovable property is available in the name of the, my lord, absconder, my lord. Then, my lord, case was filed, kindly see at page 20, lordship. Page 20, lord. Order dated 27/8/2025. Accused person named.
Thereafter, what happened?
My lord, the case was, then on the basis of that report, my lord, case was filed, lordship. After filing the, my lord, case, lordship, police is visiting to my, at my home, lordship, saying that you appear to the police station and go to the court. Now, I am not that person against whom my
Now,
search sheet was submitted.
what do you want? What do you want?
Now, problem is not, lordship. The PN is there, NBW was issued, lordship. I want to appear, I'll submit entire documents and submit application that I am not that person against whom.
You appear.
Yes, lordship, some protection may be given.
What protection?
Otherwise, my
You are saying you are not the accused in
lordship.
that case.
Otherwise, NBW is the proclamation of.
NBWN proclamation is not against you.
Well, that is the problem, lordship, unless it is, my lord, some sort of protection is
You
given.
go before the investigating officer and
Well,
reveal your identity.
IO is coming at my home, lordship. Now saying that you are that person now. Earlier, I was not that person, lordship. After, my lord, order passed on 27/8/2025, my lord, IO is saying that I am that person, lordship. That is the problem. Any sort of protection may be given. I will appear before the learned court below, lordship.
What is your name?
My lord, my name is, my lord, Mofidul Islam, son of Nurul Islam, son of, my lord, my Aadhaar card is also there. Voter card, voter ID card is there at page 21, lordship. That is my, here in Nurul Islam. My father's name is Nurul Islam.
No. How in this 528 you will get?
It is, my lord, Nur Muhammad. My father's name, not the father, name of the father of that person is Nur Muhammad. He is Mintaz Ali. My lord, search sheet is, kindly see search sheet at page 18.
No, Mr. Azhar,
Page 18, lordship.
Mr. Ahmed,
Lordship.
which order you are impugning?
My lord, that's just impugned, my lord, some, I
You have
want
not
to appear, my
filed
lord, some
any-
sort of protection, my lord. That this order may be kept in abeyance, lordship. I will appear before the learned panel.
How this order can be kept?
This
in-
filing order, lordship, NBWA. NBW so issued, lordship, that may be kept in evidence, lordship. I will appear and file application. It found that I am that person, lordship. The learned magistrate, my lord, said, so the case will be proceeded against me, lordship. Someone was not issued that was not served.
Yes, Mr.
Here, the, my lord, page 20, my lord, case is someone
Yes.
different, my lord, it's not like other cases. Here, my lord, a proclamation, my lord, was issued, again, report has come, and after that report, he was declared as proclaimed offender, my lord. Already. So there is.
No,
That
but
may be kept in abeyance,
Page
lordship. I will
20, my
appear,
lord,
lordship.
already declared proclaimed offender, my lord. So, perhaps, my lord, no protection can be granted, my lord.
Otherwise, how I
Page
will
20,
appear,
last
lordship.
part, lordship.
heard Mr. M.H. Ahmed, learned counsel for the petitioner. This application under section 528 of BNSS has been filed by the petitioner. Stop. The grievance of the petitioner in this case is that though he is not the accused in connection with GR case number 1236/2013 corresponding to North Lakhimpur PS case number 559/2013 under section 379 of IPC. And though the trial court have on unable to procure the attendance of the accused person, namely Mimtaz Ahmed alias Mufidul, has filed the case by issuing a standing non-bailable warrant against him. However, the police is now visiting his residence, stating to him that he is the person against whom the non-bailable warrant of arrest have been issued by the trial court. And the counsel for the petitioner submits that the name of the present petitioner is Mufidul Islam, son of late Nurul Islam, whereas name of the accused against whom charge sheet has been laid is Mufidul
Mimtaz Ahmed alias Mofidul, son of Nur Muhammad.
Mimtaz
Nur
Ahmed
Mahmud.
alias
double R.
Mufidi, son of Nur Muhammad.
Nur
He's-
Mahmud loss.
He submits that the trial court has rightly you have to, if wrongfully you are the police is trying to arrest you, then 528 under 528, will you get the relief or you have to approach this court by invoking writ jurisdiction? Yeah. 528, you may not get any relief. Writ jurisdiction. An innocent person who is not connected, that is your case, not connected with the case is,
As the case is already filed, lordship. My lord, that is why I have come.
no,
That's
but
because-
there is no error in the trial court's order for which the inherent jurisdiction may be involved. Your case is different. You have to,
Petition loss,
yes, it has to be dismissed.
petition is my lord, that can have also be filed lordship. Now,
You may withdraw or I will, yes. You have an option of withdrawing this.
CJM also can decide lordship matter whether I am that.
You can appear before CJM, there is no bar, but no protection under.
But this order, if it is kept in abeyance, lordship.
How we can keep in abeyance? There is no error in the impugned order.
It's not there. Now, police action is there, that is the problem.
For that you have to seek a different relief.
Then some time may be granted lordship. I'll take against that.
Time for,
Some other date may be listed.
why?
I'll take instruction whether it will be withdrawn.
Okay, okay. That will. Learned counsel for the petitioner submits that that considering the nature of relief sought for by the petitioner in this case, he may have to approach, he may have to seek some other jurisdiction of this court, and hence prays for time to get necessary instructions from the petitioner. The prayer is allowed. Let this case be listed in the next week on a date to be fixed by registry.
All right.
Item 22.
Yes,
May I please alert? Alert, here, my lord, petitioner, two petitioners, they are husband and wife. My FIR, my lord, lodged on, my lord, 31/12/2023 by the father of the petitioner number 2, my lord. That alleging that, my lord, on 25/12/2023, the petitioner number 1 eloped with her minor daughter, my lord. Subsequently, my lord, petitioner before number 1 before your lordship was arrested on 18/1/2024. And my lord, accordingly, my lord, this petition number 2 was recovered from the custody of the present petition number 1, my lord. And she was given to the, my lord, custody of her father, my lord, informant, my lord. But in the meantime, my lord, when father tried to marry off daughter, my lord, elsewhere, my lord, having no other alternative, my lord, they second time, my lord, eloped, my lord, and got married, my lord, on 15/6/2024. But on that incident, my lord, no FIR was lodged. And out of their wedlock, my lord, one child was also already born, my lord, male child on 26/2025. This is the background of this case, my lord.
who is the victim in the case?
Petition number 2.
And accused?
Accused is 1, my lord. Lordship, I have annexed their affidavit, my lord, the relevant portion at page 22, my lord, paragraph 6, my lord.
Yes, Mr. Sharma. At what stage the case is pending?
My lord, appearance stage, my lord.
My lord, here, as POCSO is involved, my lord, and charge sheet already submitted, my lord. At this stage, Lordship may issue notice, my lord, to the respondent number 2, my lord, Hussain Ahmed, my lord, and call for a record also, my lord.
My lord,
When is the next date?
POCSO is involved, my
next,
lord.
exactly, my lord, I have not taken that date, my lord. But lordship, next date now, my lord, not with me. But the case is in the trial stage, my lord, it's correct.
That is required. You can verify next. This matter will be listed on 12th of November.
Apply.
26.
And this matter pertains to Zimma petition. In this case, my lord, the trial was ended with acquittal, my lord. And after acquittal, my lord, I approached before the authority to get Zimma of this seized article. Thereafter, my lord,
These articles,
seized, my lord, track and some cash amount, whatever seized during the course of investigation. Because thereafter, my lord, after completion of trial, the case was ended with acquittal. Now, my lord, we are not willing to furnish. Thereafter, we have filed an my lord, Zimma petition before the learned trial court. However, this trial court, this case was dismissed due to non-prosecution.
then what is the error?
Error, my lord, 90 days has gone. So, my lord, due to the specific reason, my lord, the learned engaged counsel did not appear before the trial court. So my lord, 90 days is gone, so my lord, this 528 petition is filed, my lord, challenging this order, my lord, 19/5/2024.
Where is the impugned order?
So the page 112.
1-1?
112, last page, my lord.
No. What is the error in the, wrong in this order to invoke inherent
Because
jurisdiction?
my lord, he could not appear due to that reason. I have, my lord, cited the reason, page 7, my lord, the grounds.
You file a new application. That is the only remedy. Yes, mistake. Heard Mr. H.R. Chaudhary, learned counsel for the petitioner. Also heard Miss M. Dekar, learned counsel for NCB. This application under section 528 of BNSS has been filed by the petitioner impugning the order dated 19/5/2025 passed by the Court of Learned, Additional Session Judge number 1, Kamrup Metro, Goa, in miscriminal case number 26/2025. On a specific query posed by the court as to why this court should invoke its inherent jurisdiction in this case, learned counsel for the petitioner seeks some time to address this court. On the other hand, learned counsel for NCB has also sought time for getting necessary instructions in this regard. The prayer is allowed. Let this matter be listed in the next week on a date to be fixed by registrar.
May I please, your lordship? Your lordship, the conducting counsel, Mr. Arbor, has informed me telephone that he has left the court due to sudden illness. Can I adjourn for a week?
On request of learned counsel for the petitioner, what is your name?
C. Paul.
C. Paul. This case is adjourned for the day. Registry to list this matter in the next week on a date to be fixed by it.
Much please.
May it please your lordship. Your lordship, before I place the impugned order, that is at page 15, lordship, admittedly, default on the part of the petitioner to appear before the trial court, but he was filing application through, he was filing his representation through pleader, lordship. On the last date, lordship, that is on 24/9/2025, that is page 15, lordship. Another representation was filed, lordship, seeking some more time for.
What is your name?
Lordship Shankar Kumar Boni,
Shankar
NIA case, lordship,
Naik.
and
When is the next date fixed?
next date is 14. I want to appear, lordship, so till the.
You appear on 14. Heard Miss T. Som, learned counsel for the petitioner. This application under section 528 of BNSS has been filed by the petitioner, sorry, namely Shankar Kumar Bhaumik, who is aggrieved with the order dated 24/9/2025 passed by the Court of London, Additional Chief Judicial Magistrate, Kamrup Metro in NI case number 5034/2023, whereby non-bailable warrant of arrest have been issued against the petitioner. Learned counsel for the petitioner submits that petitioner is facing a trial before the Court of Learned, Additional Chief Judicial Magistrate, Kamrup Metro in NI case number 5034/2023 under section 138 of NI Act. She submits that on 24/9/2020, why you could not appear? On 24/9/2025, when the NI case number 5034/2023 was fixed before the trial court, the petitioner could not appear before the said court due to medical reasons. And the engaged counsel for the petitioner had submitted a petition before the trial court showing cause of his absence. However, the trial court, by order dated 24/9/2025, had rejected the petition and issued non-bailable warrant of arrest against the present petitioner. Learned counsel for the petitioner submits that the next date of the aforesaid case is fixed before the trial court on 14/11/2025, and the petitioner is willing and ready to appear before the trial court and cooperate in the trial. However, she submits that as pending non-bailable warrant of arrest is there against the petitioner, some interim protection may be granted to him. I have considered the submissions made by learned counsel for the petitioner. Since the petitioner is willing and ready to appear before the trial court and cooperate in the trial, this criminal petition is disposed of with a direction to the above named petitioner to appear before the Court of Learned Additional Chief Judicial Magistrate, Kamrup Metro, in NI case number 5034/2025 on the next date fixed, that is 14/11/2025. To facilitate his appearance before the trial court, the non-bailable warrant of arrest issued against him shall remain stayed till that day. On his appearance before the trial court, the petitioner may seek any relief to which he is legally entitled to before the said court.
29.
Please go. My lord, may kindly come to case 31. NBW was issued against me, lord.
Why?
For a long time. For a long time, lordship. I could not appear. I was outside lordship for earning livelihood, lordship. Lordship, my prayer is that I will appear and just trial, lordship. I may be allowed to appear, lordship. It's perfected, lordship.
What is the case?
Lordship, you kindly come to FIR at this date, lordship. FIR was registered under section 366A, but lordship was submitted under section 366, lordship. So I have annexed, lordship, page 14.
You appear?
The victim deposed, she was 18 years of
is at the time of offense.
Heard Mr. M.I. Hussain, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Putul. Putul. Additional public prosecutor. This application under section 528 of BNSS has been filed by the petitioner, namely Aftabur Rahman, who is aggrieved with the order dated 11/4/2025,
23, my lord. 11/4/2023, my lord. Page 31, my lord. Page 31.
2023 till
Next date, looks good.
order dated 11/9/20 and subsequent orders passed in PRC case number 309/2018 pending in the Court of Learned Chief Judicial Magistrate Gwalior. Why you could not appear?
Lordship, I could not appear because I was outside. I'm a laborer, Lordship. I had to.
Where outside means?
Outside in Meghalaya, Lordship. They have stated. Yes, I have.
Learned counsel for the petitioner submits that he could not appear before the trial court as he was not aware about the dates fixed in the said case, as he was outside the state, that in the state of Meghalaya for earning his livelihood. Stop. Now the petitioner has come to know that the aforesaid PRC case is fixed on dash
14/11.
14/11/2025, and he is ready to appear before the state court and to face trial. He submits that some interim protections may be granted so as to facilitate his appearance before the trial court. Stop. After considering the submissions made by learned counsel, this court is of considered opinion that since the petitioner is willing to cooperate in the trial, he is directed to appear before the trial court, that is the Court of Learned Chief Judicial Magistrate Gwalior, on the next date fixed in PRC case number 309/2019, that is on 14/11/2025. So, to facilitate his appearance before the trial court on the aforesaid date, the non-bailable warrant of arrest issued against him by the trial court shall remain stayed till that date, within bracket 14/11/2025. This criminal petition is accordingly dismissed.
Item 30.
Yes.
By this petition, also, I have challenged the FIR charge sheet and cognizance order passed by the learned JNFC Harsinari on the ground that your lordship, in this fact, your lordship, 20 numbers of buffaloes seized by the police. And case is registered under National Cattle Preservation Act. And petitioners are not named in the FIR, but they are in the charge sheet, they are there, because they are the owner of the seized buffalo children. Case is registered under section 379(4)(1) IPC and 13(1) and 6 of the Cattle Preservation Act 2021. But in the schedule, your lordship, cattle preservation.
Buffalo is exempted,
Exempt. And
but 379(4)(11) is there.
my lord. It is 17 years, the police has registered it. We are the owner, we have purchased cattle and they have seized our houses also, police. And there is no complaint from the public, your lordship, because we have to 379
we have to, your lordship, 380, we have to satisfy, because there may be public complaint that she's getting there from the there. We have on the way from the market, and it is seized, your lordship. There is no complaint, police has seized, your lordship.
You take this plea before the trial court.
Notice someone has issued the provision has taken, and already this honorable court has already decided the issue. I have annexed the judgment also.
Which issue?
That year is Buffalo is not covered.
Buffalo, I am
That is
agreeing,
normal. And
but
it is-
other offense.
Other offense, your lordship, they also said that we have, this is we have hired also Jinma, that it was not provided.
During the investigation also, they are not cooperating, they are.
When is the next date fixed?
Exactly, your lordship. 28/11/25. For it, 28/11/25.
Heard Mr. S. Islam Learned Counsel for the petitioners. Also heard Mr. B. Sharma Learned Additional Public Prosecutor. This application under section 528 of BNSS has been filed by the petitioner for quashing the proceeding of ARC case number 605/2024, in which charge sheet has been laid against the present petitioners under section 379/411 of IPC, read with section 13 within bracket 1 within /16 of the Assam Cattle Preservation Act 2021. Learned counsel for the petitioner has submitted that the accusation against the in the affair is that, what is the accusation?
Is your lordship.
That 20 numbers of buffaloes
Seized by police.
were seized by police which were suspected to be stolen. But he submits that buffalo has been exempted from the purview of Assam Cattle Preservation Act 2021. And as regards the other charges, that is under section 379/411 of IPC, there are no materials in the record stuff. The contentions raised by the petitioners are required to be examined. Hence, call for the scanned copy of the case diary of South Salmara PS case number 86/2024, as well as scanned copy of the PRC case number 605/2024 from the trial court. Who is responsible? Trial court, respondent number, trial court staff. The registry to take steps for requisitioning the aforesaid scan copy. Let this matter be listed on 11th of December.
Till that further question is taken.
No. We'll examine the
Right.
cash.
Item 41. Oh, bless.
Make this order. Jima petition your lordship. Jima for lordship, one vehicle Renault Duster car vehicle bearing registration number DR01, DA6016, and one Redmi mobile handset. And the case of rupees 42,000, your lordship.
Let me call for a report from the IO minor.
Pending investigation.
Case, your lordship, and the trial is now.
Where is the rejection order? Why trial court rejected your? Why trial court rejected your prayer? Page number?
Your lordship, 18, 19, and 20.
11 portion is page 18 minus, para 5 minus. Onwards.
Charge sheet submitted, your lordship, and the accused is in now on bail. Where is the charge sheet submitted, the investigation is not, investigation period is completed.
No, but the vehicle is liable to be confiscated. Heard Miss A. Medhi, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 528 of BNSS has been filed by the petitioner. Mohammad Firoz Alam, impugning the order dated 13/10/2025 passed by learned Special Judge Karbi Anglong, whereby passed by learned Special Judge Karbi Anglong in connection with Jimma petition number 71/2021 in Delhi PS case number 25/2025, whereby the prayer for Jimma of the seized vehicle as well as handsets and cash amount of rupees 42,000 was rejected by the trial court. Let the scanned copy of the records of the trial court in which the order dated 13/10/2025 has been passed be called for. Let also scan copy of the connected case diary, that is of Delhi PS case number 25/25 be called for.
And special NDPS case number is 66/25.
Stop. In connection with special NDPS case number
66.
66/2025. Let this case be listed again on 8th of December.
In 43. 8/12.
Huh?
8/12.
March of it.
Meet your lordship. This case, your lordship, I'm challenging the order. Lordship, may kindly peruse at page 19. Warrant of arrest has been issued against me. I was absent on that particular day, your lordship. On the previous occasion, I was present. However, on that day, may I read your lordship, page 19. Complaint.
Why you were absent?
Your lordship, there was a error of communication between me and my counsel, your lordship. However, my respectful submission, your lordship, is that the court ought not to have issued the warrant of arrest. In this connection, your lordship, I am relying on the judgment of the Supreme Court.
Where is the impugned order?
29/5%, sorry, 19, your lordship, page 19.
What judgment?
2012 9 SCC 791, Raghuvansh Devansan Bhasin versus State of Maharashtra, your lordship.
What it says?
In this case, your lordship.
Para number?
Para number 10, 11, 12, and 13, your lordship.
What it says?
That the warrant of, non-bailable, this is basically with respect to non-bailable warrant of arrest, your lordship. A non-bailable warrant of arrest should not be issued on the very first day, that is this case, your lordship.
This is not the very first day.
No, this is not the first day, but your lordship, the principle. May I read the paragraph?
No, this is not applicable.
Yes, no, your lordship, in this case, it has been with respect to the warrant of arrest. The court ought not to issue a warrant of arrest.
At the first instance.
At the first instance, as well as if the person is appearing, your lordship, if there is a possibility that the person may appear. In this case, only for this day, I was absent. Otherwise, I was represented by my counsel and I was present, your lordship. Or if for a single day I was absent, there was a communication of error, your lordship. However, the court issued a warrant of arrest. I'm ready to face the trial, your lordship. May kindly peruse the order, the judgment, your lordship. Para 10, 11, 12, and 13.
No, no, only come to the specific.
Para 10, Your Lordship. May I read, Your Lordship? It needs little emphasize that since the execution of a non-bailable warrant directly involves curtailment of liberty of a person, warrant of arrest cannot be issued mechanically, but only after recording satisfaction that in the effects and circumstances of the case, it is warranted.
Now, when is the next date fixed?
The 4/11, Your Lordship. 4/11.
Appear before. Let him.
Yes.
Heard Mr. T. Devri, learned counsel for the petitioner. If you are appearing regularly,
On that day, I was.
on that day you defaulted, what
Yes,
court should have done?
Yes, Your Lordship.
No, what court should have
No, Your
done?
Lordship, true, Your Lordship, the court ought to have, Your Lordship, but this judgment says that the court could have issued a bailable warrant of arrest, Your Lordship, not a non-bailable warrant. Okay, that is my.
This application under section 528 of BNSS has been filed by the petitioner Ranjit Khatoniar, who is Ranjit Khatoniar impugning the order dated 29/5/2025, passed in NI case number 30/2022 by the Court of Learned Subdivisional Judicial Magistrate
Gozali Patsala.
Mufassal Bajali Patshala, whereby warrant of arrest was issued against the present petitioner. Learned counsel for the petitioner has submitted that the present petitioner is facing a trial under section 138 of a NI Act in NI case number
30 of 2022, Your Lordship.
30 of 2022 before the Court of Learned Subdivisional Judicial Magistrate Bajali Patshala. He submits that the petitioner was appearing regularly before the trial court. However, on 29/5/2025, he defaulted in appearing before the trial court due to communication gap with his engaged counsel. And on that day, the trial court issued non-bailable warrant against him at the very first default itself. Learned counsel for the petitioner submits that in case when an accused who is facing trial in a criminal case is appearing regularly before the trial court and defaults on one occasion, the proper approach is to issue bailable warrant of arrest at the first instance without going directly for issuing non-bailable warrant of arrest. In support of his submission, learned counsel for the petitioner has cited a ruling of the Apex Court in the case of Raghuvansh Divanchand Bhasin versus State of Maharashtra and others, reported in 2012, 9 SCC 791. Stop. Learned counsel for the petitioner submits that the next date of NI case number 30/2022 is fixed before the trial court on
4th December. Your Lordship.
4th of December 2025. And the petitioner is ready and willing to appear before the trial court on the said day and cooperate in the trial. However, as non-bailable warrant of arrest has already been issued, he seeks some interim protection in this regard. So, I have considered the submissions made by learned counsel and have gone through the records. Since now it appears that the petitioner only defaulted on the day on which the non-bailable warrant of arrest was issued against him. Prior to that, he was appearing before the trial. And since he is ready and willing to appear before the trial court and face the trial, this criminal petition is disposed of with an direction to the petitioner to appear before the trial court in NI case number 30/2022 on the next date fixed, that is on 4th of December 2025. Stop. To facilitate his appearance before the said court, the non-bailable warrant of arrest issued against him by the trial court shall remain suspended. Shall not be executed against him till that day. Stop. On his appearance before the trial court, the petitioner may seek appropriate relief to which he is legally entitled. This criminal petition is accordingly disposed of.
I'm very grateful, Your Lordship.
Supplementary list.
May I please, Lordship? The 528 petition for questioning of trial proceeding, affair and search. The dispute arose between the husband and wife. The husband and wife bear lend and rupees time to time from the petitioner. When asked the money, they create the dispute matter. Thereafter, my lord, actual fact, my lord, the husband and wife.
Now, on what ground you are
My lord,
trying for quashing?
husband and wife, my lord.
Who are you?
No, I am for the petitioner, my lord, represent petitioner.
Your husband?
Not husband. my lord.
Third
I'm
person.
the
Third party.
nearby of the house, my lord.
Yes.
Of the village. My lord, dispute arose between the husband and wife, my lord. They went to execute a deed of separation of deed. In that separation of deed, my lord, the present petitioner was witness, my lord. Why he has made the witness in the separation case? That is why, my lord, filed this instant false case against the petitioner by the victim, my lord. Actually, there is nothing occurred, madam. There is no any physical relation between the victim and the present petitioner. As such, filed this instant petition saying for questioning of
What is the allegation?
allegation, madam.
Where is the affair?
FR is page 12 to 22, madam. Complaint petition.
12 to 22 affair.
Complaint type copy, madam. Page 12, annexure 1, madam. May I read, madam?
No.
My lord, Lordship may call for scan copy, my lord. Here, allegation is serious in nature, my lord. Here, Lordship may kindly search it, my lord. Page 28, my lord.
Charge sheet is under what provision?
Under section number 3184, 351, subsection to 64 is there, my lord. And 308, subsection to 69. Page 28, my lord.
Heard, Mr. Oh. This is item number.
59, my lord, supplementary.
Heard, Mr. B. Islam, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 528 of BNSS has been filed by the petitioner praying for quashing the proceedings of sessions trial case number T2/53/2025 arising out of Akira Gram PS case number 70/2024 pending before the Court of Learned Session Judge Koprajar. Issue notice to the respondent. The petitioner shall take steps for issuance of notice upon respondent number 2 by speed post within 7 days from the date of this order, returnable after 4 weeks. Let also the scanned copy of the trial court record as well as connected case diary be called for. The registry to take steps for requisitioning the scan copy, list accordingly.
Last part of December.
After 4 weeks.
After.
60 intermediary interim maybe.
No, not the case of
Otherwise,
my
we
interim.
will fix that. Now, tomorrow is that next deadline.
Not the
Okay.
case of interim.
Yes. Prayer for interim is rejected. Last line.
Come against the proceedings for the DB case. I'm the mother and represent the mother and the brother-in-law. Brother-in-law, Lordship, there's no allegation in the petition filed before the court, Chief Judicial Magistrate. But yet, Lordship, summons have been issued. I'm an old senior citizen. There's no allegation at all, not a whisper. And yet it affects I have a reputation in the locality. Whatever's happening between husband and wife, I have nothing to say there. But Lordship, if Lordship looks at the petition which has.
Who is the petitioner, the respondent number 1 in DB case?
So husband is not before the law.
Who is
Only the-
respondent number 2?
The respondent number 2 is the brother, it's a brother-in-law. Who doesn't?
Respondent number 2. There are 2 respondents.
That's a husband. One is the wife, respondent 2 is the husband. He's a pro forma respondent. As far as the husband is concerned, I've nothing to say. But as far as we are concerned, Lordship, they have been married barely for a few months. And apparently things are not going well. So she has even lodged an FIR on.
When is the next date fixed?
17th.
17/11. Okay, we'll issue notice. And you need not to appear on the next date fix. Then we'll examine after. Heard Miss M. Hajorika, learned senior counsel, assisted by Mr. D. Khan, learned counsel for the petitioner. This application under section 528 of BNSS 2023 has been filed by the petitioners, namely Ms. Amina Khatun and Mr. Bulbul Haq, praying for quashing of the DB case number. You are quashing only in respect of you.
Stop.
Quashing of the DB case number 17/2025, qua the present petitioners, which is pending in the court of London, Judicial Magistrate First Class Hajo, under section 12 of the Protection of Women from Domestic Violence Act. Learned senior counsel for the petitioner has submitted that the petitioner number 1 is the mother-in-law of the respondent number 1, who had lost the aforementioned DV case. And petitioner number 2 is the brother-in-law of the respondent number 1. She submits that no allegations have been made against the present petitioner in the DV case. She also submits that the dispute is between the respondent number 1 and respondent number 2, who is her husband, as well as son of the petitioner number 1, as well as brother of the petitioner number 2.
Brother-in-law.
Brother-in-law. No, Bubul Haq and
Yes, he is the brother-in-law.
Bubul Haq and
He's married sister, the respondent number 1 sister.
Okay,
Respondent number 4, respondent number 2 sister.
okay, brother-in-law of
What need you, I bet that makes it more clear.
this. Stop. Brother-in-law of respondent number 2. Your main contention is that against you, there is nothing. Stop. The contentions raised by the learned senior counsel needs to be inquired into. Hence, issue notice to the respondents. Learned counsel, the petitioners shall take steps for issuance of notice upon the respondent by speed post as well as by usual mode within 3 days from the date of this order, returnable on 18th of December 2025. Learned Senior Counsel submits that the petitioner number 1 is aged about 60 years and the next date of the aforementioned DV case is fixed on 17/11/2025. And she prays that the further proceeding of the DV case number 17/2025 be stayed till next returnable date. Stop. After considering the submissions made by learned senior counsel for the petitioner, this court is of considered opinion that if an order of dispensing with the personal appearance of the petitioners, will stay quasi till next date. Considering the submissions made by learned senior counsel as against the above present petitioners, the further proceeding of DV case number 17/2025 shall remain stayed till next date. This will, however, not affect the case in respect of the other, in respect of the pro forma respondent, that is the husband of the aggrieved person. List this matter accordingly on 18th of December. Motion है admission. Mr. Das is there. How much time will you take? 10 minutes, we can stop. If you assure that you will take 10
Before that,
minutes. Okay. cool.
my lord, the appeal has to be admitted, my lord. I'm facing for the suspension of sentence. He is already in judicial custody for about 2 years.
What is the offense?
Your lordship will kindly see page 97. There is all these 12 witnesses, my lord, not a single eyewitnesses for the.
No, what is the offense? 302. Then
304,
then they may file. What is the?
My lord, I'll just point out one thing, my lord. Your lordship will kindly take the main petition, my lord. Main one. Writ appeal.
Okay, before that, in main criminal appeal, heard Mr. B.D. Das, learned senior counsel, assisted by Mr. D. Kolita, learned counsel for the appellant. This appeal under section 415 of BNSS has been filed by the appellant Sanwar Hussain, impugning the judgment and order dated 18/7/2025 passed by the Court of Learned Session Judge Gwalpara in Sessions Case number 112/2016, whereby the present appellant was convicted under section 304 Part 2 of Indian Penal Code and was sentenced to undergo rigorous imprisonment for 7 years and to pay a fine of rupees 5,000, and in default of payment of fine to undergo further simple imprisonment for 4 years, 4 months. Issue notice to respondent number 2. The appellant shall take steps for issuance of notice upon respondent number 2 by registered post by speed post as well as by usual mode, returnable on 16th of December 2025. This appeal is admitted for hearing. Let the records of the trial court be called for. The registry to take steps for requisitioning the trial court record. Steps within 7 days. Yes, Mr. Bashar.
Hello, then may I just submit one page? Page 97 of the main petition, your lordship, can you see? As a part of the judgment. There is not a single incident, eyewitnesses, only my lord, conviction is based on the petitioner's appellant statement under section 313, my lord, CRPC. Page 97, para 105. And may I just read this, my lord?
Yes.
So now from the appreciation of evidence of the prosecution witnesses, as well as the extrajudicial confessions and admissions of the accused made under section 313 of CRPC, it is crystal clear that the accused person has no any criminal intention to kill his wife, but in a heat of moment while he strangulated the neck of his wife, as this tried to save her paramour from
Yes,
the clutch of
Mr. Bashar, have you gone through?
My lord, not my lord. Even my lord, apology, my lord. Somehow, my lord, my lord, this petition is misplaced, my lord. So, my lord, let the TCR maybe call for. In the meantime, my lord, we will go through the same and make our submission now.
And only on the basis of 313 statement, he has been convicted.
No, let him go through so that he can oppose your prayer.
So your
We
lordship
have
will kindly
admitted
give
the appeal. On the next date, we will consider your.
suspension. Your lordship will kindly give us a date.
Yes. Date given.
2 years already received custody.
16. Heard Mr. B.D. Das, same Lihibu. This application under section 430 of BNSS has been filed for has been filed by the applicant praying for suspension of sentence imposed on him by the judgment and order dated 18/7/2025 and 25/7/2025 respectively, passed by learned Session Judge Gwalpara in Sessions Case number 112/2016. The applicant has impugned the aforesaid judgment by preferring the connected criminal appeal number 364/2025. Stop. Learned counsel for the petitioner applicant has submitted that the conviction of the applicant in the aforesaid case has been erroneously made by the trial court solely on the basis of his statement recorded under section 313 of CRPC. He further submits that the petitioner is detained behind the bar for last 2 years, and there is every possibility of getting a favorable order in the connected criminal appeal, and therefore he submits that the execution of the sentence imposed on the applicant may be stayed till the pendency of the connected criminal appeal. On the other hand, learned additional public prosecutor has submitted that due to inadvertence, the copy of the interlocutory application got misplaced. And therefore he seeks some time to go through the records before he may. Now you have the copy.
My lord, I have requested my senior, they will provide.
Okay. Learned counsel for the applicant undertakes to provide a copy of the application. So issue notice to the respondent number, opposite party number 2. The petitioner shall take steps for issuance of notice upon all the opposite party by speed post within a period of 7 days from the date of this order, returnable on 18th of December, 16 December. 16 December, list according.
Oblige.
Lordship has 6 minutes. 6 minutes, much less than 10 minutes.
Okay.
May I please your lordship? The LCR was called for lordship and we have obtained the certified copy of the victim's statement lordship.
Why NCR was called for?
Lordship today, 228 days lordship.
Victim has been examined.
Examined lordship. There are contradictory statements of the victim lordship. The victim stated in the affair that she came to know on 9th January, but already she came to know in the chamber of doctor on 7th February lordship. And the affair
Regarding
was
her pregnancy.
lordship. And
Victim
one
is
girl child,
pregnant.
yes, regarding pregnancy, she came to know after 7 months lordship. So lordship, when she came to know on the 9th or 7th February, she filed this affair lordship on in the month of March, 2nd March. That is 23 days or 22 days delay lodging the affair lordship. And lordship will find the affair page 14 lordship, 17 lordship, kindly lordship. At page 17 lordship.
No, how many witnesses have been examined?
Only one, the victim girl lordship.
2 more independent witnesses are there.
Lordship. Lordship, in the meantime, lordship, the petitioner will cooperate with the trial lordship at any condition lordship. Today, 228 days lordship. And already in our petition lordship, already stated that she had some relation with other person lordship. That's why the family members of the petitioner lordship did not accept that whether the child given birth by the victim of that petitioner or not. There is a doubt lordship. But a petitioner will cooperate at any condition lordship. Today, 228 days lordship, and a victim has been cross-examined, and next date is fixed on 2nd January for PW2 lordship. In the meantime, lordship, at any condition, the petitioner will cooperate lordship with the trial.
So earlier occasion, my lord, amicus, my lord has placed that my lord that is recorded, that my lord this, apart from the, my lord, that is the statement of the victim, my lord. There is another 2 material witnesses are there. In this regard, my lord was pleased to, my lord, call for the, my lord, the status report. My lord, I have gone through the, my lord, office note, and also, my lord, there is a flag mark that is, my lord, R, my lord, in the, my lord, office note. But, my lord, the present case is, my lord, that is a session case, my lord, 39/2025. Maybe some inadvertent mistake, my lord. The report regarding session special case 39/25, that was, my lord, communicated, my lord. So, my lord, so we don't have that, my lord, report from the end of the, my lord, trial court, my lord. So that maybe you want to correct it, my lord. Next date maybe fixed, my lord. Flag R is there, my lord. Where it is stated as, my lord, session special case, my lord, 39/25. Our case is, my lord, session case, my lord, 39/25, my lord.
Yes.
Your lordship, even so, even though the victim has been examined, your lordship, I'll still stand the ground that there are 2 material witnesses, your lordship, at page 37 of the petition, your lordship. Your Lordship got it, 37.
37? Yes,
Lordship, the last paragraph.
yes,
May I read, Your Lordship?
yes.
Chandan Kalita and Chanakya Rabha, hotel staff, confirm the victim's visits to the hotel and
A. Bushra, learned additional public prosecutor, as well as Miss M.K. Brown, learned amicus curiae, appearing for the respondent number 2. Though it appears from record that a status report of the trial, along with the deposition of victim girl on her examination, was called for from the trial court. However, learned additional public prosecutor has pointed out that the report which has been received by the registry, which has been sent by the learned session judge Nalbari, is in respect of sessions within brackets special case number 39/2025, arising out of, what is the PS case?
Yes, case, Lordship.
Arising out of PS case number 73/2025.
Not-
Whereas he submits that the case involved in the instant case is Sessions case number 39/25, not Sessions within brackets special case number 39/25. Therefore, he prays that another date may be granted and a reminder may be issued for receipt of up-to-date status report from the trial court. On the other hand, learned counsel for the petitioner has produced the certified copy of the order dated
Two dates, Lordship. The order dated 14/08 of 2025.
14/08/2025,
5 and
as well
another
as 17/10/2025, and submits that on perusal of the said orders, it is apparent that the victim has been examined and cross-examined on the said dates and has already been discharged. He submits that next summons have been issued to two more witnesses, namely Jonali Rajvanshi and Kamal Dekha, and the date of the next date is fixed before the trial court on 2/1/2026. He further submits that since the victim has been examined and since the petitioner is ready to cooperate in the trial, and since he has been detained behind the bars for more than
28 days.
for last 228 days, he may be allowed to go on bail. He submits that he is ready to abide by any condition which may be imposed by this court while granting bail to the petitioner. On the other hand, learned amicus curiae, Miss M.K. Brown, submits that two more independent witnesses who are very crucial for prosecution case are yet to be examined, namely Shri Chanakya Rabha. How many total witnesses are there?
witnesses.
Shri Chanakya Rabha and Shri Badan Kolita. And she submits that if the petitioner is released at this stage, there is a likelihood of trying to influence the independent witness by him. Hence, she objects the grant of bail to the petitioner. Stop. I have considered the submissions made by learned counsel for the both sides and also gone through the materials available on record. Since the certified copy of latest order along with deposition of victim girl has been produced by the learned counsel for the petitioner, the non-receipt of up-to-date status report from the trial court may not be relevant at this stage. I have gone through the statement recorded by the statement of the victim. I have gone through the deposition of the victim girl, which was recorded by the trial court. So without commenting on merit of the case, this court is of considered opinion that the apprehension shown by learned amicus curiae appears to be mere apprehension at this stage. And as the victim girl has already been examined, cross-examined and discharged, if the petitioner cooperates in the investigation, his further custodial detention may not be necessary for fair completion of the trial in the aforesaid case. In view of above, the above named petitioner is allowed to go on bail of rupees 50,000 with one surety of like amount, subject to the satisfaction of the learned trial court with following conditions. Trial conditions. This bail application is accordingly disposed.
42.
So in this case, Lordship, during the pendency of this bail application, charge was filed. And Lordship, charge is yet to be filed. And petitioner Lordship is behind the bar for 118 days. And your Lordship may kindly come to this 7 is the FIR.
What is the offense?
POXO is there, Lordship.
Then you go before the trial court.
But
Trial court can consider and when charge sheet has been filed. The victim has not yet been examined.
no, my charge is yet to be filed.
Charge is also yet to be filed.
And that two co-equals Lordship has already been granted bail by this honorable in anticipatory bail, Lordship.
During investigation.
Yes. Lordship, I have annexed that order. There are some discrepancies in the statement of the victim also, Lordship, considering on their perspective.
When charge sheet has been, Miss Chaudhary, you are appearing for. You have anything to say?
Charge sheet is August 26.
Amicus curiae appearing for the respondent number 2. Number 2. Learned counsel for the petitioner has fairly submitted that though this petition was filed. Though the petitioner had filed this application, what is your ground?
Considering the discrepancies of the statement of the, well, a serious allegation he has brought, Lordship, but these are not supported by medical document, Lordship.
Though the petitioner had filed the application during the pendency of the investigation of this case, however, in the meanwhile, charge sheet has been laid bearing charge sheet charge sheet has been laid. Learned counsel for learned additional public prosecutor as well as learned additional public prosecutor also submits that charge sheet has been laid bearing charge sheet number
The seat number 181 dated 26/8/25.
since the trial court at the first instance after laying of the charge sheet is the best court to consider an application regarding bail, and since no application has been filed by the petitioner before the trial court after filing of the charge sheet, this bail application is disposed of with an observation that the petitioner may approach the trial court and may file an application, may file a regular bail application before the said court, if so advised.
Item number 53. I'm an interim on the main criminal petition, my lord, in the main case.
All the family members are in. It's not today, my lord.
53, that may be extended, lord.
Or day after tomorrow. Item 43. All family members fine.
Item 43. Item 43 on Friday,
Friday or Thursday, my lord.
Friday.
As you wish.
My lord, I'd like to mention item number 34, my lord. Interim order may be continued.
Wherever interim is there, interim will be continuing and remaining cases registry will give the dates.
Lordship, item number 53 in the main criminal petition, my lord. 396.
Interim will continue wherever interim is. 53,
And for the
yes, 53 interim.
Lordship, with
Or
regard to
remaining, no mentioning.
Lordship,
Item my lord 39. Or put case is fixed on my lord 15. It will be on my lord either 14 or 39. Trial court my lord may be on 15.
39 day after tomorrow.
Lordship, with regard to item 52, Lordship, because I have made it mention this item, Lordship, because it's not listed for a long time.
When do you want?
19, Lordship.
19.
May it pleases, my lord. May it pleases, my lord. My lord, with respect to item number 55, my lord, there is an interim order.
Interim, wherever interim is there, it will continue.
Item number, lordship, 50, lordship. Interim, can it be on Friday, lordship? 50, at 0.
Interim is there.
Interim is there.
Interim is there, then registry will fix the date.
May please, your lordship, beg to mention item number 48. The petitioner is violating the bail conditions. He's on interim. May kindly be fixed it tomorrow or the day after. I'm for the respondent number 2.
Monday,
I'm for the petition amendment.
Item 48 and my learned.
48 Monday.
Monday. Monday is. May please, your lordship.
No more mentioning.
Lordship.
My lord, in this case, interim is there.
Interim will continue till Monday,
My lord, 17 little difficult for me. my lord.
Tuesday.
Oblige.
Lordship, I'd like to mention item number 64 of supplementary list. This matter may be come up day after tomorrow, Lordship,
Any urgency is there?
because there is a law point and this is a bail application. So in the earlier occasion, the Lordship has asked me to prepare a note regarding arrest of, ground of arrest. Or the
Okay.
Monday, that can be fixed on Monday also, next,
64 Monday.
obliged.